Greetings,
Is it mute?
and thank you so much to all of you for being with us today. Welcome to day 2 of the Symposium on Reparations under International Law for Enslavement of African Persons in the Americas and the Caribbean, sponsored by the University of the West Indies and the American Society of International Law, and facilitated by the UE Center for Reparation Research and BASIL, the Blacks of the American Society of International Law. I'm Chantal Thomas. I'm a co-chair of the Symposium Organizing Committee alongside my co-chair, Natalie Reed. And I wish to thank once again the sponsors for this event, and especially Judge Patrick Robinson, ASIL President Catherine Amerfar, and Vice Chancellor Professor Sir Hilary Beckles of the UE for making this event possible. We look forward to a wonderful set of discussions today, beginning with the current panel on global and comparative perspectives on reparations. It's my pleasure to introduce Professor Charles Jallow of Florida International University College of Law, who will moderate the panel and introduce our highly distinguished speakers. Professor Jallow, I turn it over to you.
Thank you so much, Professor Thomas, Excellencies, distinguished colleagues, ladies and gentlemen. Good afternoon, good evening, and perhaps even good morning, depending on where you are. My name is Charles Jallow, and as Professor Thomas just said, I'm a professor of law at Florida International University in Miami. I am deeply honored to have been invited by the University of West Indies and the American Society of International Law, as well as all the facilitators of this event, to moderate this important panel discussion on global and comparative perspectives on reparations.
Hello, and as
the overarching theme,
professor of law at Florida International.
The overarching theme of what was yesterday rightly described as an historic symposium, reparations under international law for enslavement of African persons in the Americas and the Caribbean, is an important and timely one. It is to me quite significant that this topic, which like the twin evils of slavery and colonialism that languished in the peripheries of international law discussions and debates, is increasingly being moved from the periphery to the center of international law discussions. While there has been much scholarship on reparations over the years, this symposium should help enrich that body of work and to shine a well-deserved spotlight on it. It is without a doubt worth noting that the Center for Reparation Research at the University of West Indies, together with the Blacks in the American Society of International Law, one of the most well-known and respected professional bodies of international law, have joined forces to put together what has so far been a truly fantastic and thought-provoking symposium. Needless to say, without the leadership and support of Judge Patrick Robinson, Honorary ASIL President and Judge of the International Court of Justice, and the President of the American Society, Ms. Catherine Amerfar, this symposium would not have been possible. I wish to therefore take this opportunity to extend my our collective gratitude to them for putting together a really stimulating conversation, which I followed very closely, like many of you yesterday. Allow me to now turn to the business at hand. The theme of the panel that I've been asked to moderate is global and comparative perspectives on reparations. We have two very distinguished speakers who will address the topic from two complementary perspectives. The first of them is Mr. Umberto Adami, who will be followed by Mr. Claudio Grossman. I will introduce them to you as they speak. Later on, we'll get a chance to engage in a Q&A, so I invite you to start thinking about and writing down your questions. I have strict marching orders that the speakers are to get 15 minutes each for their remarks and to reserve the second half of the panel for our exchange of views, including with the audience. So allow me to now start with an introduction of the first of our distinguished speakers, Mr. Umberto Adami. Mr. Adami has a long list of impressive professional accomplishments. So I must apologize in advance that I'm not here able to do justice to it, since I would limit myself to highlighting a select set of things from his professional background. He is currently the president of the National Truth Commission of Black Slavery of the Federal Council of the Brazilian Bar Association and president of the State Commission for the Truth of Black Slavery of the section of OAB. He has chaired the IAB Racial Equality Commission and is the former vice president of the National Commission of Racial Equality or the Federal Council of the Brazilian Bar Association since January 2014, and a member of the National Commission of Environmental Law of the Federal Council. He is a lawyer specializing in actions to combat racism before the Supreme Court of Brazil, and is a partner of Adami Advogados Associados. He is also a member of the Board of Superior and professor at Zumbi del Palmeiras University since 2011. In terms of education, he holds a bachelor's degree in law from the University of Brasilia and a master's degree in law from the State University of Rio de Janeiro. Mr. Adami will speak to the topic, reparations for transatlantic chattel slavery in Brazil. Mr. Adami, you have the floor and the next 15 minutes for your remarks, sir.
Thank you, Professor Charles Jalop. Pleasure to be in this meeting with Professor Claudio Grossman. I would like to thank you to the American Society of International Law and the University of West Indies. It was a very important meeting, and I'm watching since yesterday, and it was very important. And I saw yesterday Mr. Jude Hobson, and was saying just in a few moments that he looks like a hero of the Brazilian reparation. Black reparation is Mr. Iedo Ferreira, that is a griot about the fights for Black reparation. And I was very happy to see yesterday my very good friend, Gay McDougall, that came to Brazil in 2005. And after having a connection with the amicus curiae of Michigan University lawsuits, that was very important with Ted Shaw, and they came here with in a connection of Ford Foundation, and we have a lot of very many connections here, and it was very important to saw him here yesterday. I want to say that in Brazil we don't have this. There's no meaning about the chattel slavery that all people are saying here. We talk about black slavery, and we can understand everything about slavery and black slavery. So I want to talk about the chattel slavery meaning. I say it was said that the Black Slavery Truth Commission of the Bar Association, the Brazilian Bar Association, I mean the third time that we have in the presence of this institution, and also of the Brazilian Lawyers Association with the Racial Equality Commission. We have 18 state chapters and a lot of municipality commissions, which has a lot of linking, working, and the reparation fights around Brazil. Brazil have 27 states, and it's so large. So this possibility of rescuing the heroes of the fights of the Brazilian, the black people in Brazil is a lot. It's very important, because in Brazil they make something that forgot all the Brazilian fights, the Brazilian black fights, and the Brazilian black heroes, and the Brazilian that helped to make the country, and the Brazilian black people were forgotten. So talk about reparation in this points of the conversation is asking about the completely forgetness, those heroes. I was also watching yesterday Dr. Hilary Beckless that makes some very similar speech with Professor Hélio Santos in Brazil. In many times I saw Hélio Santos and Professor Hélio Santos and Professor Hilary Beckless talking the same thing. And I think that's a reparation, a black reparation points that we can identify is the same thing talked in many places in different language, but it's the same thing that are being said. The heroes that the Black Truth Commission has with very good results, and probably it will be the first time that many people that are watching us will heard. So Luiz Gama, which was a lawyer at that fight for the fight for the liberation of Black people in Brazil. Also, Esperança Garcia, who was a woman that made a very important letter talking about freedom in Piauí. And also nowadays we talk about Manuel Congo and Mariana Criolla. Probably it is the first time that many of you hear about those heroes of the fights of the freedom in Brazil. But it's important to say, to remember, and to tell about this. We have in Brazil 5,753 municipalities. So it's in Brazil. So it's a lot of history, places, and to rescue from the complete forgottenness. And some time ago, very recently, we have the Brazilian Supreme Court talking about police lethality, and in an important lawsuit that is going on in Supreme Court. And police in Brazil kills a lot of, especially the young Black Brazilians. Also, we have for 2 times the Brazilian Supreme Court talking and regulating about affirmative action with quota system, and also university and public job, public examinations admission. And this was what we can consider like revolution. Even in Brazilian bar associations, last November, the Federal Council of the Bar Association ruled that in the next elections, in the next November, we will have a 50% vote for women in the elections, and also 30% of Black people, male and female, in the election, which make me feel that the bar association in whole Brazil will never be the next. It is a real revolution. And also, I would like to talk about reparation, transition justice, and also we made just 2 weeks ago a very important webinar, international, with a lady of Namibia, and that talked the importance of slavery reparation with the Federal Bar Association. We made some 1 year ago with the University of Pennsylvania, a very important seminar. We received 15 students of the University of Pennsylvania talking about reparation in Brazil and United States, and talking about this lawsuit of Namibia against Germany, which happened in a court of New York. It's very, very interesting, and we are watching very hardly this way. Well, I think that I don't know about the time. We have time, Professor Charles. We still have time. All right. So there's a very important thing with the Brazilian Lawyers Institute. We made a very important document that says about the juridical aspects of the reparation of the slavery reparation, and this document is on the site of the institute with about 18 pages, and we treated all about reparation, slavery reparation in Brazil and also the world, because lots of people talk about reparation, but then when you are going to ask for reparation, write for reparation, it is still difficult, and it's a very hard subject. And I always finish saying in Brazil what I say, let's make, it's the first time that I say it in English, but let's make the ground of this earth tremble. So in Brazil, we say, vamos fazer tremer o chão dessa terra. So in English, let's make the ground of this earth tremble. That's what I invite everybody to do. And thank you very much for hearing me.
Thank you. Thank you so much, Mr. Adami, for your very thought-provoking remarks on the situation of reparations for transatlantic chattel slavery in Brazil. I took careful note of your point about the language that we used yesterday in the panel. So it's a very interesting, even comparative point. I'll be coming back to you in due course with some questions. I now have the pleasure of moving to the second distinguished speaker for our panel today. Although Claudio Grossman does not, in some respects, need an introduction, I do wish to say a few things about him, even though, like the case for the previous speaker, I will not be able to do justice to his extensive professional accomplishments. Professor Claudio Grossman is a professor of law, Dean Emeritus, and the Raymond Geraldson Scholar for International and Humanitarian Law at the AU Washington College of Law, where he served as Dean from 1995 to 2016. Claudio, I say Claudio, is a colleague of mine, is a member of the United Nations International Law Commission and was chair of its drafting committee in 2019. In 2019, he was also elected to the l'Institut du Droit International and appointed to its Commission on Epidemics and International Law. Since 2014, Professor Grossman had served as the president of the Inter-American Institute of Human Rights, and he served as a member and chairperson of the UN Committee Against Torture and as chair of the UN Human Rights Treaty bodies. From 1993 to 2001, he served on the Inter-American Commission for Human Rights and was twice elected as that body's president. He also served as the Commission Special Rapporteur on the Rights of Women and Special Rapporteur on the Rights of Indigenous Populations. He has participated in landmark human rights cases, more or less throughout all the universal and inter-American and regional systems. He is the author of numerous publications concerning international law, the law of international organizations, human rights, and international education. He is the 2020 recipient of the Gola T. Butcher Medal, awarded by the American Society of International Law to a distinguished person for outstanding contributions to the development or effective realization of international human rights law. His proposal on reparations to individuals for violations of human rights and humanitarian law was approved by the ILC for addition to its long-term work program in 2018. With that background in mind and keeping his scholarly contributions on the subject also in mind, I do not think we can have a better speaker for his intervention on the topic, remedies for gross breaches of international law, with particular attention to transatlantic chattel slavery. I now give the floor to Claudio, my friend and colleague. You have 15 minutes, sir.
Well, many thanks for your introduction. I'm honored to have been invited to talk at this important conference of the American Society, co-sponsored by the American Society of International Law and the University of West Indies. I am also honored to be in this panel with Umberto Adami and with you, with Professor Charles Jallow. I recognize also and value tremendously the intellectual and moral leadership of Judge Patrick Robinson. We would not be here without him, had it not been by him. I will analyze first the development of the law of reparation concerning obligations to individuals under international law. Then I will turn to current mechanisms and practices for implementing reparation owed to individuals. And I will mention also obligations owed to states. I will consider whether international law provides a framework for addressing the arms of enslavement and the slave trade. Traditionally, international law was exclusively defined as law applicable to the relations between states. Individuals increasingly gained the ability to bring international claims in national courts. In 1928, the Permanent Court of International Justice, in the case concerning jurisdiction of the courts of Danzig, declared that individuals may have the right to bring international claims to national court. As a result of the horrors of the Second World War, a common framework began to develop regarding the concepts of human dignity and individual rights, creating rights international at the international level, including the right to reparations. It's important to know, however, that even in 1926, the international community had reacted against slavery with the adoption of the Slavery Convention. And after World War II, the international community again decried enslavement and condemned it through the proclamation of the Universal Declaration of Human Rights and the adoption of the Supplementary Convention on the Abolition of Slavery and the Slave Trade, and institutions and practices similar to slavery in 1956. The Rome Statute also incorporated slavery as an element of the definition of crimes against humanity. One of the most relevant developments to a concept of reparation is the adoption by the General Assembly of the UN of the basic principles and guidelines on the right to a remedy and reparation for victims of gross violations of international human rights law and serious violations of international humanitarian law, the basic principle, adopted in 2005. Almost all the universal and regional conventions established the right to the reparation and the ability to individuals to act when states have accepted that possibility. Reparation under international law also have been studied through the work of the International Law Commission. For the purposes of reparation, the topics of diplomatic protection and state responsibility are of particular relevance. The International Court of Justice in the Ahmadou Sadio Diallo case stressed the interconnection between the rights of the individual and the concept of diplomatic protection, providing reparation for that it was important to consider the reparation for the injury suffered by Mr. Diallo in breach of international law. The ILC in the early work on the Articles of State Responsibility that laid down norms concerning reparations to state for wrongful acts and recognized the importance of reparation, established also as a pending work the need to continue with reparations to individuals. On the basis, because the Articles of State Responsibility detailing particularly the issue of wrongful acts owed to states, other states of the international community, and identify restitution, compensation, satisfaction, either singly or in combination. Following the spirit of the Article of State Responsibility, I presented a proposal adopted by International Law Commission to this time undertake the job of codification and progressive development of reparation to individuals. Now, what concerning now the exercise of the right to reparation, it's possible to do that both at the international and national level. At the international level, we have all the plethora of norms in the universal and regional established, for example, in the United Human Rights Treaty bodies, or in regional courts, the Inter-American Court of Human Rights, the European Court, and the African Court of Human and People's Rights. What has emerged is a law on reparation that includes obligations to redress and rehabilitation. That redress includes effective remedy and access to justice. Full reparation is achieved through restitution, compensation, rehabilitation, satisfactions, measures of non-repetition. Those interested, I recommend them to take a look at General Comment 3 of the Committee Against Torture, adopted by the Commission Against Torture, that details the content of all this important concept of reparation. An essential component of reparation is the prohibition against discrimination. And important also for the topic at hand is the autonomy of reparations to penal liability. The alleged perpetrators do not need to be apprehended or convicted to generate a full reparation. Essentially, is to in the law of the reparation the concept of victims that include individual and collective victims, family members, and dependents, or those who suffer harm. Harm is broadly defined, physical or mental. Very important also is in the law of reparations that the victims are not simply the object of reparations. Attuned with the developments of international law, the law of reparations established that this is a system victim-centered, and accordingly, reparations require the participation of the victims. This is a secondary regime, meaning this regime of reparation is triggered by the violation of a primary norm of international law, as we're going to analyze that concerning chattel enslavement, but it shows the path to follow when a violation has taken place. And also takes care of some of the criticism that exists against the reparation in case of enslavement, chattel enslavement, for example, because of the notion of victims or the issue that the perpetrators cannot be found today. That's not part of the law of reparations now. In order to set the issue of reparation also, it's important to mention that a variety of societies have used transitional justice principles to promote peace and justice in the aftermath of mass atrocities. 4 common characteristics of transitional justice have been identified: seeking truth, pursuing justice, providing reparation for victims, and reforming institutions. This development in the context of transitional justice promote broader goals that also are relevant in this case, including reconciliation and economic development. Repairing past harms symbolize the international community and recognition of victims' suffering, and public provision of reparation contributes to healing, which promote reintegration in the transitional society or when we deal with grave violations of human rights. Now, reparations arising from chattel enslavement. Chattel enslavement is recognized as a crime against humanity. Enslavement is recognized as a crimes against humanity. The organization of this, the creation of wealth, its brutality, the inhumanity of making the enslaved person a piece of property, whose descendants inherited their mother slave status with little hope for freedom, are just a few indications, brutal indication of this horrendous crime. The scope of this crime is tremendous. An estimated 11,328,000 Africans were delivered to nations across the Atlantic, with around 13 million having left African ports. In addition, the abuses perpetrated, including all the cycle, the moment of capture and sale, before being forced on slave ships, slave traders often branded enslaved with hot iron. The transportation across the ocean led to additional physical and psychological harm, including separation from family culture, overcrowded conditions, constant exposure to disease, poor ventilation. Patricia Sellers talked yesterday about the sexual crimes committed during all the process of enslavement that by themselves are the crimes against humanity, of course. It is not wonder that the shock wave from this horrendous crime of enslavement and the transatlantic slave trade continue to be felt today. The global trade of enslaved Africans and slave-made products required the development of, was important for the development of modern finance and led to a creation of new industry. National economies were, however, not alone in reaping benefit from the slave trade. Business and corporation, including banks and shipping companies, individually benefited from this trade. Reckoning with the arms of enslavement is not just a question of the past. Slavery still exists around in the world, today around the world. The International Labor Organization estimated that in 2016, 40.3 million people were victims of modern day slavery. Forms of slavery and practices similar to slavery include human trafficking, forced labor, debt bondage, and servitude. There are an estimate of 24.9 million victims of human trafficking around the world. In 2017, the Inter-American Court delivered its first decision concerning slavery and human trafficking in the case of Hacienda Brazil Verde Workers versus Brazil. As mentioned in the panels yesterday, the ramification of the slave trade and enslavement can be also felt through racial societal structures that continue to be maintained. It is difficult also to deny that different forms of modern slavery are, as a minimum, facilitated today because there was not a reckoning with the past that is very much present today. Now, in terms of theories concerning the applicability of international law to reparations, Scholars have proposed a variety of theories. For rhetorical purposes, or there are components, different components in all of them, but just to summarize, let me put some together. The first denies the applicability of international law to remedy the arms of enslavement, and basically mention the principles of non-retroactivity and intertemporal law. However, it should be noted that while new peremptory norms do not generate a retroactive assumption of legal responsibility, it's not clear that there were no principles that at that time that the chattel enslavement took place that defy the direct applicability of the principle of intertemporal law. Also, a state might agree to compensate for damage, always, and the agreements could be a source of the creation of a practice with international legal significance. According, I'm going to talk more about this theory later when I cover the basis identifying the theory that is relevant for international law. Let me say also that in a similar vein, some have argued that there is no longer a causal connection. It's not only based in the intertemporal principle, but there is no causal connection between the harm that occurred and those presently seeking reparation. Yesterday, Gay McDougall listed all the objections, and I refer everyone to the excellent panel that she conducted today. But the legal complexity of identifying victims and determining what is owed does not, however, excuse a state obligation to embark on such an inquiry when reparations are due. A second legal theory contends that the international legal framework is racist and colonialist, and that states who insist on applying the intertemporal principle are insisting on the application of colonial law. Both theories have a similarity in the sense that they don't see a role of international law. In response to proponents of the position that reparation for slavery is barred by the principle of non-retroactivity, Antoine Boyce argues that the notion of continuous violation under international human rights framework could be applied to a context of reparation. And the concept has a continuing character that extends over the entire period during which the act or event the state was obliged to prevent, continues, and remain. For the sake of time, I'm not going to give all the arguments involving the application of the continuity source for an obligation. I would say also that the slave trade contributed to the development of modern finance and the creation of new industries. In the Belgian context, King Leopold II appropriated an estimated $1.1 billion in today's money from Congo. One can argue that, as Sashi Tharoor states, that the obligation to pay reparation is rooted in the common law principles of restitution and unjust enrichment for reparations as much as possible to restore victims to a pre-victimized states. Additional arguments that were presented yesterday, among others by Nora Whitman and Mamadou Heavy, include that transatlantic chattel enslavement violated international law at the time it started, and different grounds are invoked in that line. One, that international law is not equal to European law writ at large. And on the basis of comparative studies, the notion of just war and penal law that different societies outside the European realm follow justify slavery to a certain extent in the cases of a just war or criminal law as a penalty, but not chattel enslavement. This idea of people as commodity, their descendants, and the whole structure of organized production, horror, and brutality. The International Law Commission is codifying now the general principle of international law, and some of us are establishing that the general principles of international law, quotation mark, accepted by civilized nations, end quote, was an obsolete concept already when it was adopted. I also would like to say that the argument for the continuous application of international, the argument on the grounds that the law at that time did not accept chattel enslavement were not grounded in the universal character of international law, not the European character. Also, as Judge Robinson stated, even in European law, we can find, for example, as he quoted, as mentioned by in 1562, that the Queen Elizabeth statement to Captain Hawkins, the 1815 Vienna Declaration on the Abolition of Slave Trade, with direct reference to humanity and morality to interpret the Treaty of Paris of 1814, determining that we were in presence of principles that have existed always for ages, questioning the legality of transatlantic slave trade on the basis of general principle of law. I would like to add that it's necessary to engage in further comparative analysis involving the recognition of the humanity of all persons, also in the origin of this brutal form of enslavement, the enslavement for chattel. For example, the expression of Father Las Casas establishing that the Indians had a soul, were grounded on this idea of common humanity, and we don't find these statements that would partialize the existence of human beings. There are different expressions of that, and again, because of time, we are not going to cover this, at least in the first round. The siete partidas, these are one of the terms that I can mention without a problem of pronunciation, also establish basis for the common humanity of individuals. I also would like to add that even in the 16th century, additional arguments could be made involving the idea that there were contemporaneous notions of imperative norms of jus cogens, in the sense that certain things could not be done, even at that time. And that created a serious problem to argue that the chattel trade did not include, if not in totality, very important concepts that even at that time were considered violating this notion that some things could not happen. I will say that the Nuremberg principles built on this idea that there are basic notions that, because of relevance and their importance, lead to consequences in international law. I will mention also the following, that international law has been able to develop and assume the challenges of our time. International law is a living instrument that, through interpretation, norm creation, has been able to address issues facing humankind. The process of decolonization, the creation of human rights norms, the principles of Nuremberg, the content of the principle of non-discrimination, the law of reparations. So this is very essential then to understand that what is before us is not only the topic of reparation for enslavement in case of the chattel slavery, but what is at stake also is the relevance of international law to address key issues facing the international community. And we see in practice the development of a space at the international and the national level, stressing the need to address this topic. In Belgium, in England, there are significant movements for the acknowledgement of the consequences of slavery. In the United States, the Pentagon has begun the process of changing the names of army bases that are currently named after the leaders of the Confederacy. More recently, Evanston, Illinois became the first US city to enact reparation scheme for African American victims of city historic racist housing policy. The United Nations Special Rapporteur on the topic has also identified examples of domestic efforts to to establish reparation programs, including the monetary settlement of the government of Canada with indigenous people. Let me finish my comments, asking for your tolerance if I exceed my time, stating and repeating something. What is at stake here is the relevance of international law to address key issues facing humankind. Thank you very much.
Thank you so much, Claudio, for your excellent remarks. I will, of course, be picking up on a number of the themes that you've highlighted so well. So let me go back and make one point and actually start the conversation with Umberto, and I'll come back to you, Claudio, a number of critical points that you've raised. And of course, I also promise that I'll go to the chat and see if there are questions there from our audience. So to Umberto, I found quite thought-provoking your comments and comparative perspective, especially looking at the issues of systemic racism and the movement and call for reparations in Brazil, comparing to developments in the United States. You highlighted a number of things that are quite common in the conversation. For example, the issue of police brutality against especially young Black men. Obviously, that's an issue that is quite relevant for the debate in the United States, especially given recent cases. These are not exclusive cases, but the cases that got a lot of attention, not just in the United States, but also around the world. And you also highlighted the issue of affirmative action and measures that have been taken to ensure that Brazilian society is more reflective of the aspiration of the principle of equality. So can you, as taking from that point of departure, point out if you see any synergies between what is happening in addressing these issues now, for example, in the US, but also globally?
Yes, the George Floyd happening and death, and it started a lot, explosion of protests all around the world. In Brazil, the Brazilian Black movement were shouting a lot of time, but sometimes it was listened and sometimes it was not. A lot of activists of the Brazilian Black movement are very prepared to the discussion that more and more becomes a specialized discussion with a lot of lawsuits at the Supreme Court, all these affirmative subjects rules, like the examination of the public admission. It starts to have a lot of lawsuits with the individuals that are going to get the job. So lots of courts start to discuss and rule. So we have to be, as a lawyer, be prepared. And it's always the same thing, but especially because of this government, the federal government nowadays, we get some places back, and people start to discuss again the affirmative action and the quota system. I don't agree. Well, but it doesn't matter if you agree or not. It's the law. And so, but I think I always say, and people from the affirmative action sometimes be angry, because the affirmative actions objects sometimes is a bit small for the slavery happening in Brazil 350 years. So you cannot find that you will make a response and about all the horror with some jobs or some places at the university and some places at the jobs, the public jobs. It's so small. So, but it's very important. But so you sometimes start to stay with the dog running after itself. So the reparation, the slavery reparation, talking space, slavery reparation discussion is a bit more, it's so large that you find more space, although it is difficult, but you have some permanent subjects of the Brazilian black movements, like the Quilombos fights, the black churches, the Brazil with Ubanda. I call black church because I don't find other way to translate, but the religious fights that Umbanda and Candomblé people are always being postponed, being persecuted, and always you find a lot of things. So go to slavery reparation subject is to go more ahead and be connected with Africa, be connected with Jamaica, be connected with the United States, and be connected also with the Black Lives Matter and movements. So we are very, very happy to be part of this huge movement, and a lot, especially the young people, they are fighting very hard. So I think we are in a good movement. We have a lot of problems with the lethality of the police, but every day when you open the newspaper, you have cases of police brutality, police killing people, and but in the same time you have this movement that goes ahead and ahead, and now I think it's the time that go ahead the slavery reparation, which is a very difficult. One thing that was very important is going behind memory in all places of the country, in all municipalities, and fighting for the finance reparation. I remember that I went to the United States in the International Visitor Leadership Program, and I went to the Tulsa Memorial in Tulsa, Oklahoma, which is part of the discussion. A lot of time, the Tulsa finds, the Tulsa killings stayed very hidden in the United States, and then they still probably going ahead. And the reparation now movement is going United States and also in Brazil. We have to go and go and go. That's the remark.
Yeah, thank you so much. I think you make a number of important observations, especially highlighting the broader. So we could move from essentially the individual cases of affirmative action and so on, and then move on to the Black Lives Matter movement. But there's an interesting connection to the bigger issue that is of more systemic nature. So yesterday we had some very interesting discussions, starting with the opening panel by Sahila Rebekos, essentially trying to explicate on the place of slavery as an institution, but not just as an institution, but as an economic institution. And on top of that, clarifying that it did not just end there. You then had the subsequent policies, and this came out throughout the rest of the panels in terms of what is called Jim Crow in the United States, of systemic oppression from and keeping down of those particular communities. So really, really very important connections that you're making to the wider issue that was covered and discussed yesterday. Claudio, if I may come to you, keeping in mind that we are going to probably be running a little bit low on time, to just pick up on one important point. I love the way you connected the discussion today with the discussion yesterday, especially keeping in mind some people may not have had the opportunity to follow everything. Luckily, everything is recorded and it's really worth the watch. Now, if I go to the central questions around the legal aspects that you covered so well, Claudio, especially this notion about the place of international law, which one could argue was part of the system of oppression, right? But you also gave us a more hopeful side about the place of international law, essentially as a site of redemption. So in your view, Claudio, what are the implications for international law if it remains silent on the impact and legacy of the transatlantic slave trade and its consequences?
Well, Charles, thanks for your question, and also thanks to Umberto for his excellent contribution and comments. Well, I think we do not have good experiences when we do not address key issues facing humankind. It's very important to channel essential issues through the legal principles, because otherwise we're confronted on different notions of justice, who is stronger and who is weaker. And international law, even the European international law, had concepts that in changing circumstances are valid. The principle of sovereign equality, for example, it was an essential problem. The generation of norms. So everyone has contributed to the reality of international law that is international law. And I will mention the concept of self-determination, for example, or as a very important, or the law of reparations. We mentioned the different venues of reparation. And when we're seeing, and Umberto was talking about this, and you ask all over the world, this aspiration of people of addressing topics that are essential and continue to have a fundamental impact in society, the idea that international law doesn't have an answer has serious implication in relation of the type of societies where we want to live.
Indeed. Sorry, Claudio, I'm going to have to jump in. I realize that we're going to be running out of time. We have a couple of minutes. I just saw just now a couple of questions in the chat, but I'm afraid since we don't have the opportunity now to extend the conversation, we'll probably have to leave it there. For the next couple of minutes, I don't know, Umberto, if you want to take 1 minute to give final reflections, and Claudio, I'll come back to you maybe with 30 seconds, final remarks, because we have to end right on the hour so we can have everybody the 10-minute break, and then they will come back for the next panel.
30 seconds.
Yes.
Well, yeah, I think that we must do many events like this, because we have a lot of things to talk, a lot of things to change. And someone asked for the heroes. Yes, we have to find the heroes that were forgotten, bring them to this place to say, we made this country, we made the world, and we have to have the recognition. And a lot of people earn money that and they have to pay, because the slavery was a history crime, like Eero Ferreira always says.
Indeed. Thank you so very much, Umberto, for being so brief. Claudio, 10 seconds.
Well, sometimes I hear the following thing. I heard in the Committee Against Torture, Inter-American Commission. Why this problem and not other problem? Huh? You know, where do you start? Where does it end? And in the practice and development of human rights law, the idea that in order to advance in a topic, you need to advance in all the topics, has not been the practice of international law. So there are certain conditions why certain topics are the object of international community. But never in the development of human rights law, the idea is, unless you advance in everything, you don't advance in anything. Let me finalize thanking you and Umberto Adami and all the co-sponsors for this panel and for having invited me. Thank you again.
Thank you so much, Claudio, and thank you to Umberto. I'm grateful to you for your excellent presentations and your insights. It's clear that we just started the conversation, but I hope that we'll be able to continue this conversation. Luckily, we have another panel coming up. Yesterday was fantastic. I'm sure the rest of the day will be fantastic. So please join me in giving a huge virtual round of applause to our two distinguished speakers. The next panel is on the legacy of enslavement, contemporary dimensions and remedies. It will start, I believe, in about 10 minutes or so. I thank you and bye-bye for now.
Pleasure. Thank you. Thank you, people. We are out now. Professor Charles, Professor Claudio.
Bye-bye to you. Bye, bye. I hope to see you in Brazil or in any other place. Bye-bye.
Bye-bye.
Dr. Levitt, you're muted.
You know, I don't like to be muted, Wes, so if I muted myself, it's okay in this case. Welcome, everybody. My name is Jeremy Levitt, a professor of law, Florida A&M University College of Law, which is significant because it's the country's largest historically Black university, law school, one of 5 in the nation. And for a topic on the legacy of enslavement, contemporary dimensions and remedies, we have 2 absolutely wonderful speakers, one from UCLA, the other from Loyola, Los Angeles, and myself, the moderator, the one being born and raised in Los Angeles. So we're connected, but not connected here at the same time. First, let me just introduce the first speaker, Tendayi Achiume, a star in the profession who's made quite a large splash. In fact, I might say it's a tidal wave in just a short number of years. Professor of law at UCLA, former faculty director at the UCLA Law Promise Institute for Human Rights, and research associate with the African Center for Migration and Society at the University of Witwatersrand. But most importantly, I think now her work is really having an impact in terms of the law doctrine, norms, and so forth that she is trying to put in place in her role as United Nations Human Rights Council appointed special rapporteur on contemporary forms of racism and racial discrimination and xenophobia and related intolerance, and certainly should be celebrated for the first woman to serve in this role since 1993. And then we have my brother Eric Miller, of Scottish and Jamaican descent, which means he has very hot blood. And so we know that he's going to adequately provoke us. A professor of law and the Leo J. O'Brien Fellow at Loyola Law School, Los Angeles, a former law clerk to Judge Stephen Reinhart on the Ninth Circuit. And he focuses on the intersection of criminal justice with sociology, criminology, and the study of problem-solving courts and legal theory. So we're in a great space for an informative lecture. We're going to keep to the time best we can to allow for a Q&A session, which should be about 30 minutes. And without further ado, I'm going to pass the table to Tendayi, and she's going to give us an education that is needed, not just in the legal academy, but I would say in the United States writ large. Thank you.
Thank you very much for that kind introduction, Jeremy. And I want to start off by saying that the work that I do would not be possible without the really important work that you and others within Basel have done to chart the way for people such as myself to be able to be in the roles that we are in the way that we are. And as you say, I am joining you all from Los Angeles and want to acknowledge my presence and UCLA's existence on the traditional, ancestral and ceded territory of the Gabrielino and Tongva peoples. To the organizers of this conference as well, I want to say thank you very much for including me in this timely and really pressing symposium. You know, I want to also thank the other participants who I think so far have provided a wealth of valuable insight regarding reparations under international law for enslavement of Africans. And it's really a powerful and humbling experience to be a part of an event involving some truly pioneering forces in the field of reparations. So my remarks today are based on a report that I submitted to the UN General Assembly in 2019 in my capacity as Special Rapporteur on Contemporary Forms of Racism. And the report was entitled Reparations for Racial Discrimination Rooted in Colonialism and Slavery. For those of you who haven't had an opportunity to take a look at it, I recommend it because it goes into far more detail than I'm going to be able to go into in the next 15 minutes. But what I thought I would do in the time that I have is give some background for the motivations of the report that I produced, and then also speak directly to some important ways that we should understand international legal obligations borne by states to provide reparations and to think about remedies. And in many ways, my comments build on comments that have been made by prior speakers as well. So we're currently just past the midpoint of the United Nations Decade for People of African Descent. And 2021 also marks the 20th anniversary of the Durban Declaration and program of action. And as many of you will know, the World Conference Against Racism, which took place in Durban in 2001, and the regional conferences that led up to the Durban conference, involved among, if not the most powerful transnational mobilizations for a global human rights system that's adequately equipped to address racial discrimination in the contemporary moment. And the issue of reparations was very high on the agenda of those who were involved in Durban, as I'm sure Gay McDougall could tell us, who was on a panel yesterday. In the regional conferences leading up to Durban, activists, scholars, and many others made a very powerful case for reparations for colonialism and slavery to take center stage. And for the responsible nations finally to be held accountable for reparations for slavery and colonialism. But they faced serious opposition from Canada, from the United States, and from European nations for reasons that should be obvious. And in the time after Durban, so in the period after 2001, the issue of reparations has seemingly been a marginal one within the United Nations, a third rail, so to speak, among its member state bodies, and especially among the former colonial powers within the UN. And I think it's important to highlight that these former colonial powers, or the First World, however you want to refer to them, which are, the Western liberal democratic bloc within the United Nations, self-conceptualize, I would say, as the guardians of the human rights framework. But ironically, it is this very bloc that has been the most resistant to reparations for slavery and colonialism and to addressing racism and racial discrimination, including within the global human rights framework. In my work as special rapporteur, I would say that the marginalization of reparations, whether we're talking about in one-on-one conversation with UN member states or within the UN framework as a whole, I would say that this marginalization is typically achieved not through an outright denial of the responsibility for slavery and colonialism, or even a denial of the utter horrors that they entailed. Even though I think there are definitely many who are denialists about slavery and colonialism. I would say that in my experience, the marginalization of discussions around reparations for slavery are typically achieved by saying, reparations aren't possible or they're not available under existing legal frameworks, right? So yes, we can concede that slavery and colonialism were bad, and yes, we can concede that there are certain powers that were responsible for them, but the project of reparations is just one that's entirely impossible under the legal framework that we have, and given questions around feasibility. And then sometimes you'll also hear arguments around the idea that these are problems that are of the past. Slavery and colonialism happened in the past, we've moved on, and so we should be focusing on more contemporary challenges. And, nothing could be further from the truth. And this is not a case that I have to make to participants in this symposium. We are all gathered here because we understand that colonialism and slavery and the ramifications and the legacies of them are not in the past. They're very much a contemporary issue. But I would say that among the many arguments I'm having to make in my capacity as special rapporteur is the claim that indeed there is a contemporary relevance here. And so as I imagine it, or as I experience it, the battle for reparations within the UN system is a political battle, and it's often one that's articulated in legal terms. And my report, events such as the symposium, I believe are vital for pushing back against a status quo that has been hostile to an international movement for reparations. And that background is the background into which I published the 2019 report on reparations that my remarks are based on. In the time that's remaining, I want to make a few points that I elaborate upon in my report, and many of them actually were made very eloquently by Professor Grossman in the previous panel. But I think they bear repetition because of their importance to the conversation that we are having. So the first is that reparations generally are a fundamental and established remedy under prevailing international law and principles. And too often, as I've mentioned, debates about reparations for racial injustice begin from the premise that reparations are inherently exceptional or an unusual remedy. And yet reparations as a holistic and effective remedy for those who have suffered a wrongful act are far from novel. And rather, states routinely provide reparations for wrongful acts and violations to one another and even to their own citizens. And they're also, reparations are a fundamental aspect of both international law and international human rights law, international practices, tribunal decisions, and other sources of international law that have long held that state breaches for legal obligations entail responsibility to provide full reparations. The draft articles on responsibility for states for international wrongful acts, which Professor Grossman also discussed, happen to be silent on reparations for harm caused by legal acts. And a lot of the debate when it comes to reparations for slavery revolve around whether slavery was legal at the time and in which it was most rampant. But as many of the panelists who've spoken have really highlighted, that kind of approach, which is based in concerns about the intertemporal principle, in addition, the questions around whether slavery was wrongful at the time are ones that really can be addressed within a public international law framework as well. So we've heard persuasive rebuttals to being this an absolute, to these kinds of arguments being an absolute bar to reparations for slavery. And it's important to highlight that even under the current doctrine of the intertemporal principle, direct and ongoing consequences of wrongful acts that extend to when the act is considered internationally wrongful, as is the case right now, do incur liability for reparations. And so we should be understanding the project for reparations. And I think many of the speakers who've spoken already have articulated this sort of understanding, which is one I push for in the report. We should be understanding reparations as encompassing two dimensions. Historic racial injustices of slavery and colonialism that remain largely unaccounted for today, but which nonetheless require restitution, compensation, satisfaction, rehabilitation, and guarantees of non-repetition. But just as urgently, reparations are urgent to address contemporary racially discriminatory effects of structures of inequality and subordination that have resulted from the failure to redress racism from slavery and colonialism. And so when we think about entrenched structures of racial subordination, whether we're talking about the United States, whether we're talking about Brazil, and I know my co-panelists will give some examples specifically from the United States, these structures are direct products of regimes of enslavement and the de facto caste systems that remain firmly in place right now, and doing these structures of racial injustice are part and parcel of a comprehensive approach to reparations. And I should note, as I do in the report, that the obligations to provide reparations are fully entrenched in international human rights law, including Article 6 of the International Convention for the Elimination of Racial Discrimination, which requires reparations for racially discriminatory human rights violations. My point, or the point that I'm trying to make here, is not that there are no legal barriers under existing doctrines of international law when it comes to thinking about achieving reparations. But my point is that those barriers are typically overstated, and the existing laws could sustain far more than we are led to believe. But instead, what we encounter is a legal formalism that obscures the full potential of existing international law to support reparations for the injustices of colonialism and slavery. And it's worth pointing out, as I do in the report, that international legal doctrine has had a longer history of justifying and enabling colonial domination, and even in some cases justifying the acts of enslavement and the slave trade, than it does a history of guaranteeing equal rights to all human beings. And I think to the extent that legal barriers exist, we should not treat those barriers as insurmountable. And in fact, we should treat those barriers with suspicion and target them as subjects for a decolonial project for those of us who are invested in the decolonization of international law. And here I agree with Professor Grossman with the idea that the international legal project can be a decolonial project, one that very much centers the project of reparations for slavery as achievable and as urgent. And also, I think it's important to highlight that, and this was highlighted in yesterday's conversation as well, that reparations for slavery were paid and they have been achieved for certain groups, but typically they've been achieved on a racially discriminatory basis as well. And so reparations have gone to enslavers and their descendants rather than to formerly enslaved. And so Britain, for example, which paid the equivalent of today about 65 billion pounds in contemporary terms to compensate enslavers, we might think about the expenditure that is represented by that figure for reparations, but not to formerly enslaved, to the enslavers instead. And I'll point out, as sociologist Guraminda Bambra has, that when we think about the reparations that Britain paid to former enslavers, it turns out that the UK didn't finish paying off the bond that it had taken out to pay former enslavers until 2015. And if you think about that, it means that you have people in Britain who up until 2015 as taxpayers were contributing to the payment off of that bond to enslavers, right? When we're still here having conversations about whether reparations for formerly enslaved are viable. And so I guess I just want to conclude by saying, if the same commitment and ingenuity that transformed entire peoples into property and implemented a global structure of domination, which we refer to now as the system of slavery, if even a fraction of that commitment and ingenuity were applied to the issue of reparations, I don't think we would be living in the current reality. We would have a very different reality. And I think this kind of symposium is the kind of intervention that is required to shift our reality to one where conversations around reparations begin from a starting point of them as being achievable, but just requiring commitment at the international level as well. So I will pause there and look forward to our Q&A.
Thank you, Tendayi. Brilliant, and a great stage, I think, has been set for Eric to come in now with some specifics about what some have called a genocide here in America, certainly massive human rights violations and displacement. And so I want to hand now the microphone to Eric. We're going to hold questions until the end, and hopefully both panelists will be able to engage the questions that you have. Eric, please proceed.
Thank you. And I mean, it's hard to follow such a powerful presentation. You know, as a descendant of enslaved people myself, it's just powerful to think of myself and my British Jamaican family literally paying our enslavers by paying that bond. So the descendants of slaves are paying their enslavers reparations. That's really powerful. So I want to talk, in some ways, take a quite parochial turn, but in other ways, quite a universal one, to think about reparations for the Tulsa Race Massacre of 1921. And Tulsa, Oklahoma is in the front line of the battle for reparations in the United States. And to understand why, I'll give you a little bit of history to help you see what's going on. So in the early morning of June 1st, 1921, white Tulsans, including the State National Guard, as well as people deputized by the county sheriff and the city police, murdered as many as 300 Black American residents of the Greenwood district of the city of Tulsa. They razed 35 city blocks to the ground and looted the homes of 10,000 Black residents. The massacre was all the more shocking given the thriving nature of Greenwood, a cultural and business center. The district was segregated by race, but in Tulsa, the Black neighborhood was thriving at the same rate or perhaps even outstripping the white district. Black pioneers in medicine, in the hotel industry, in film and theater and music, whose innovations in Tulsa made an impact around the world, lived and thrived there. So impactful was the massacre on Black business and entrepreneurialism that a recent Harvard study found that it accounted for a national pause on Black patent filings around the United States in the year following the massacre. Black people flocked to Oklahoma in part because it only became a state in 1907, and before that, it was territory run by various indigenous nations who treated Black people very differently than in the segregated South and North. Throughout the United States, for the 50 years prior to the massacre, states like Louisiana, Alabama, and Mississippi had been waging a violent campaign to enforce a form of segregation that looked and felt like slavery. For Black people, Oklahoma was, in the words of novelist Ralph Ellison, the promised land. For Black Americans, Tulsa was called the Black Wall Street. The massacre was thus an attempt at ethnic cleansing. The white citizens of Tulsa, who arrived more recently than many of the Black citizens, backed by their state, their county, and the municipal government, sought to grab the lands and the property of the Black Tulsans living in Greenwood. The massacre, as I mentioned, began the night of May 30th, 1921, and continued into the morning of June 1st. White citizens, deputized by the police and county sheriff, burned down 36 to 38 city blocks. 3,000 terrorized people fled the city. The rest were rounded up and held under armed guard for days in internment camps at the local baseball park and convention center and hospital. Children were separated from parents. Overnight, 5,000 African Americans became homeless. The Red Cross mobilized to provide tents for the thousands who remained in Tulsa, and they lived in Red Cross tents over that winter. So the hot spot for the battle for reparations in America is over who gets to determine the remedies for the survivors, for the diaspora, and for the still remaining Black Tulsa community. And the last two issues, addressing the claims of the diaspora and rebuilding community institutions, are ones that are shared by reparations efforts everywhere. And that's where I come in, because I'm part of a litigation team that is currently pursuing a public nuisance claim against the county and city of Tulsa and some other entities. So I want to talk a little bit about this, this litigation. So what's a public nuisance? Oklahoma law defines a nuisance as unlawfully doing an act or omitting to perform a duty, which act or omission annoys, injures, endangers the comfort, repose, health, or safety of others, or in any way renders other persons insecure in life or in the use of property. And a nuisance is public if it affects an entire community or neighborhood. So the claim is essentially that the positive acts of some person, in this case the county, the city, and the Chamber of Commerce, through their involvement in the massacre and its aftermath, and indeed through continuing acts of racism and intimidation lasting until this day, created conditions that did and still undermine the health and safety of the community, in the Black community in Tulsa. Because a public nuisance is, in effect, a continuing harm, it does not face the statute of limitations problems that other lawsuits face, and in particular, lawsuits under brought under the Equal Protection Clause of the United States Constitution through the enabling statute 42 United States Code, section 1983. And I was part of a litigation team that brought a federal lawsuit in 2003, and we failed on statute of limitations ground. And I just want to echo again Professor Achiume's insight that it is a mixture of formalism and exceptionalism that prevented that litigation, because we modeled that litigation on a number of other lawsuits, including the Holocaust survivors litigation. And the statute of limitations was told in the Holocaust litigation, but not in Tulsa. And we can perhaps in the question and answer think a little bit about why that might be, but I think one hint is that to the extent that the statute of limitations is lifted, the result is too transformational for judges to contemplate. Okay, so the classic public nuisance claim is someone opening a pig farm next door to you And the smell and sanitation undermines the safety of you and your community. And another version is citing a chemical manufacturing plant in a poor community that has a similar impact on health and safety. Here, the pollutant was and continues to be white racist violence, along with the continuing underdevelopment of the Black community in Greenwood and North Tulsa through the white community's attempt to take its land. The plaintiffs in our lawsuit are 3 living survivors. So we have someone who's 100, Hughes Van Ellis, 106-year-old Lassie Randall, and 107-year-old Viola Fletcher, as well as 3 descendants of individuals, 1 killed in the massacre, 2 rendered homeless, a church, Mount Vernon AME, that was burned to the ground, and the African American Ancestral Society of Tulsa. The lawsuit identifies 7 defendants who have contributed to the public nuisance or unjustly enriched themselves at the expense of the Black citizens of Tulsa. So in addition to the city of Tulsa, the county, and the Chamber of Commerce, we're also suing in their official capacity the sheriff, the state National Guard, and for the continuing harms of segregation and blighting the living conditions of the Black, Greenwood, and North Tulsa communities. We're suing the Tulsa Metropolitan Planning Commission and the Tulsa Development Authority because they acted, along with the city and county, to isolate the Black community from the rest of Tulsa and fragment the community, the Black community itself, through city planning initiatives that ran a freeway through the middle of the city. And of course, they cited it in the Black part of town. Now, here's where things get interesting, I think. The principal remedy for a public nuisance lawsuit is abatement, which essentially eschews direct monetary payments to individuals, the federal solution, and instead focuses on remediating the damage caused. So it would involve, in the case of the pig farm or the chemical plant, some kind of superfund style abatement to move the farm somewhere less populated, or to take the chemicals out of the soil. Since the harm to the community in Tulsa was to undermine its business and political leadership, preclude economic and social development through restrictive zoning, substandard infrastructure, and the creation of food and health deserts, as well as redevelopment that ran highways through the community to both split it apart and split it off from the white community, abatement is going to have to redress these wrongs. Simply put, when the assault is on the human, social, and political capital of a distinctive community, then the remedy must be to recreate that capital, perhaps through direct payments, but in this case, by empowering the community to determine for itself the sorts of institutions that it wants and needs to create a safe and healthy neighborhood. This aspect of the litigation, self-determination, is, I think, at the heart of reparations. Reparations is, on my view, best defined as a significant, ongoing, intergenerational wrong that continues to oppress a discrete group or community. I happen to think this definition fits reasonably well with historical and international notions of reparations. But it also applies, and it also focuses not just on slavery, what I would call reparations back then, but it applies to what I would call reparations right now, which would include both the Tulsa experience, but perhaps things like violent policing targeted at discrete groups. So we've seen that in Chicago. The difference between reparations and distributive justice is that we can identify a wrongdoer and a victim. Even if the wrongdoer is no longer around, the victim is. Part of what it means to be a victim is, I think, to have a duty to lift oneself out of victimhood if one can, by resisting the wrong or the wrongdoing. But part of being a member of a community in which there are victims is having a duty to help out in that process, not by dictating a remedy, but by empowering the victims to determine for themselves what that remedy should be, and if that remedy is reasonable, to help them put it into effect. Reparations, on this view, is a bottom-up process of group empowerment. It's a form of transformational justice grounded in the classic transformational ideas of truth, justice, and institutional reform. But most of all, it's grounded in the people who still suffer from wrongs that, though perhaps historical in their origin, are present and felt in their everyday life right now. So I hope that what we're doing in Tulsa has more than a domestic application, that whatever the legal justification for reparations, which is the usual focus of discussions of reparations, remedying intergenerational injuries needs more than simply a payment, a monument, or a scholarship. We need to transform not just our reparations with those who have wronged us to put us on equal footing with them. We need to transform our relationship with ourselves to lift all of us up, the direct victims, the diaspora, and particularly those at the bottom. That, for me, is the lesson of reparations. And that, for me, is why I'm so excited about the public nuisance model and why I think it fits reparations so well. Thank you. You're muted.
Wonderful, and thank you for that, Eric. I will be looking at the chat for questions, but I want to start out with one to throw out to the two of you. As I listen to you, Eric, I never look at Tulsa in exclusive terms. I look at Tulsa, I look at Colfax, Louisiana, I look at Rosewood, I look at the Achiume massacre here in Central Florida. I'm wondering if there is a theory of liability that one might conceive when you begin to aggregate all of these various massacres and what we would call, even under modern international law terms, genocides of Black populations, their displacement, their systematic denial of land that was owned, the land that was never returned. And we have some scholars that have worked on the questions of land. But I'm wondering whether there's a collective theory of liability that might be looked at perhaps at the federal level. And then as well, we're seeing more efforts taken at the local level with reparations. For example, the Florida legislature passed reparations legislation for the victims of Rosewood. A lot of people don't know that, but they did. There's been recent legislation here, which was reparations legislation for the Achiume massacre, but ended up being a watered down bill on education for victims. And I'm wondering whether working locally through legislatures is one way, and whether we need an expanded theory of liability, meaning that where you have perhaps a more progressive legislature in another state, perhaps a free state, could that free state decide to pass legislation that would give reparations to persons in other states who were affected by enslavement itself? So almost looking at a collective responsibility theory as opposed to a collective liability theory, and having a more progressive state wanting to support those victims of enslavement that were in a neighboring state. Just thinking out of the box a bit, I want to throw that at you as questions come in and let you guys chew on that a bit. Go ahead.
Yeah, that's really interesting. So newsflash, just today, Representative Jackson from Georgia was planning to introduce reparations legislation to Congress to provide remedies for so essentially waiving the statute of limitations and redefining the cause of action so that descendants can file lawsuits to essentially resuscitate the federal claims against the state, city, and county of state of Oklahoma and city and county of Tulsa. So there is something that the federal government can do. A big question is whether the federal government bears some responsibility for these local outbreaks. And so I suppose if we were thinking in terms of something like Cooper versus Aaron, a 1950s case in which essentially the federal government failed to adequately protect the integration of the high school in Little Rock, Arkansas, maybe, if we want to have a legal hook to pin it on, that might work. But I actually think that thinking about the wrongs and the different wrongdoers is important. So I want to some extent, resist a homogeneous understanding of reparations because it is addressing wrongdoing, and we need to hold the wrongdoers accountable, and at least identify who they are, because part of the toxic legacy of oppression is, as we're experiencing in the United States, to deny that the oppression happened and to prevent people talking about it. In Tulsa, the state acknowledged that it engaged in a 70-year conspiracy of silence to hush up the massacre, but we're seeing the Republican Party engage in a concerted effort to hush up a similar white supremacist insurrection in on January 6th of this year. One that I'm glad you mentioned, Colfax, looks not unlike an attempt by white supremacists to reverse the result of a hotly contested election in 1871 in Louisiana, the Colfax massacre. So I do think that it's important to take both an international but also a parochial lens to reparations, in part so that we can start the truth process of transformational justice by calling out and holding accountable the right people, but also that we can uplift the right victims. And I do think that reparations is certainly in this American model, United States model, a bottom-up process. And I think that that is what's really so powerful about it.
Tendayi?
So I guess what I would add, two things on the question of whether you could build out to broader charges or broader theories of collective liability using, say, the framework of genocide. I can't speak to the federal level. That is not where my expertise lies. And I think Eric has dealt with that pretty eloquently. But, at the international level, we might think about the movements that have been driven by Black Americans in the past to charge genocide at the level of the United States and to say, at the level of the United Nations, and to say we have to reframe the ways that we understand exactly how racial subordination and the human rights violations that result from that are understood and talked about within the international framework, where there can be a tendency to remove things like genocide that was conducted under the rubric of slavery and its legacy from the genocide framework. So I would say that even though you didn't ask about the international level, you're asking about the federal level, I think there is value and pressure to be put on international lawyers, among others, to really think about how frames that have been deployed at the international level for other groups might also fit some of the charges that have been leveled, I think, against formerly enslaving powers as well. So yes, I think that there is space for that kind of an approach. And then to just speak to the question of local interventions, I think they're absolutely vital. And in the international context, when we think about how international obligations are fulfilled, we focus on national entities taking steps to fulfill those international obligations, when international obligations kind of apply across the board. And if you can have energy and dynamism and movements at the local level that can, fulfill international obligations, I think that's often where the energy is the strongest. I think those are really vital. And we have to think about how in the international discourse, we don't lose sight of the local and the regional and all of these other micro levels that are urgent for the push for reparations as well.
And just to build on that point, too often I think in the international context, we get a payment from one institution to another institution, and that's where it stops. And I think that money needs to trickle down, to the people who are at the bottom, who are the real, still ongoing victims. As I said before, it's nice when one university gives another university money for scholarships. That's great. but that's not going to undo the ongoing history of reparations and or legacy of slavery. And so that's why we need to reform ourselves as well as demanding that others transform themselves.
That's wonderful. There's a question from those participating, Gabrielle Hemmings. She says, Ms. Achiume says, international law can bear more than we've given to it to deal with reparations for chattel enslavement. She asked the question, are there any areas left to build out to make those reparations a reality?
So, yes, I think there definitely are areas that require additional attention. And I think even at the level of doctrine, so many of the interventions that we had from panelists yesterday were really fleshing out, I think, the kind of refined understanding of international obligations and, to provide reparations for chattel slavery that I think need to become more mainstream within international law. So when I was producing my reparations report, one of the things that I did was actually just do a survey of international legal scholarship that gets to the doctrine of how we understand legal liability. And I would say that the scholarship that makes the affirmative case for reparations under international law has been marginalized. And so I think there is work to be done, including by institutions such as ACIL, to help make these kinds of accounts more mainstream. And I see this sort of engagement like the one we're having is absolutely vital for that kind of an approach. But I think one thing, and here now I'm speaking in my capacity as special rapporteur, one thing that I think remains deeply troubling is how some of the barriers to achieving reparations come from deeply held sensibilities within, especially first world nations, about exactly what slavery entailed in the first place, right? So I know we are lawyers here, we're used to having conversations about sophisticated legal theory, but there are fundamental misconceptions that I think dominate the way that most people in the United States, in Canada, in the UK, understand slavery and its centrality to the nation and what it might mean to even begin to repair. That the task of just public education, I think, is one that would go a long way to unlocking the potential of existing international doctrine to provide reparations. So the battle, I think, has to be fought in multiple arenas. And one of them, I think, is just retelling stories about, or retelling the history so that people are fully aware. And I might point to something that I haven't discussed, but the ongoing debates in the US Congress right now, where there is a bill before Congress that has been there for many years that involves creating a commission that would study the case for reparations in the United States. And I think the congressional hearings that happened this year suggested that there may be momentum here. And one of the things that arose in the context of those discussions is the urgency in places like the United States to have a full and official reckoning that would pave the way for, pursuing liability. So I think shifting sensibilities is part of the work that is required for us to move closer to a world where we can do more with the doctrine that exists. And then where the doctrine is a barrier, it's important to think about how that kind of sensitization might also help shift the doctrine. And then maybe the final thing that I will say on this question is, last year's racial justice uprisings that we saw after the murder of George Floyd, which began, in the US and then kind of went viral, to me, should be connected to this conversation around reparations in a number of ways. One of them being, how do we decide what reparations will look like? I agree with Eric that in thinking about what reparations entail, we should have a comprehensive conception, but that conception, I think, is most powerful when it is rooted in social movements, when it is rooted in everyday experiences of ongoing racial subordination that's tied to slavery and colonialism. And so if we're thinking about what we as international lawyers can do to unlock the potential for achieving reparations, part of it, I think, is being better connected to some of the movements that I think are most active right now in giving voice to what it would mean to transform existing structures of racial subordination.
Let me ask both of you a question. I'm sorry, Eric. You can just build in your answer to this, because I want to just provoke you a little bit with this question. We tend to speak about reparations in very binary ways with victims and victimizers. I want to broaden that just a little bit. We know that there was a massive slave trade from the eastern portions of Africa into the Middle East and Asia. Perhaps more prolific and more brutal than what we saw with the transatlantic slave trade. We know that there was African participation in West and Central Africa, particularly many of the larger coastal kings that participated. What they knew, how they knew, whether they were aware it was chattel slavery in a way that it developed is a different question. But I often wonder, do we lose credibility in the conversation about reparations when we don't take a holistic view and look at all the potential violators, even if that means looking at ourselves? Oh, please, Eric, that's all you.
But Tendayi, you unmuted first. No, and then happily muted him 10 minutes later. So I do believe that we shouldn't run away from asking hard questions about reparations. I was at one of the HR 40 congressional hearings, and one of the other witnesses, this was in 2019, was trying to say, hey, look, in America's past, it was the Democrats that were the oppressors, not the Republicans. And so it's hypocritical for the Democrats to support reparations. No, it's not. The Democrats should say we did it and we need to atone, and HR 40 is the first step to doing that, so that we can engage in the truth part of truth, justice, reparations, and institutional reform. So I think that's really important, and I think it also ties in with a point that Professor Achiume made about storytelling. So the interesting thing about Tulsa, and we might think about this applies more broadly, is that in Tulsa, it's always been white folks that tell the history of the Tulsa Race Massacre. They did it by silencing the story in 1921, but now they want to tell it by founding a historical site and engaging and encouraging in essentially massacre tourism, where the money goes to the Chamber of Commerce in the city and not to Black folks. But I was rereading just the other day our lawsuit and some of the documents associated with it. And our lead plaintiff from 2003, a guy called John Alexander, served as a domestic worker in a white household. And I was contacted by the son of the scion of that household. And he said, just the other day, and he said, I can't understand why Mr. Alexander filed that lawsuit. Well, it turned out that John Melvin Alexander had been angry about the massacre, at least since his service in the war in 1942, when he was ashamed to tell his boatmates that he was rendered homeless by the massacre. And he was one of the first people that met us when we went down to Tulsa. And the story that someone tells when they're the victim of a genocide, working in the house of the people who did the genocide to them, is different than the story that they tell their families. Because, what are you going to tell the person who burned your house down? That you're the bad guy? No, you got to lie. And so resistance takes many forms. And who gets to tell the story allows us to avoid accountability and responsibility. And so freeing us to tell the truth, the first step, I think, of transformational justice, is so very important because, I'm from Glasgow. We're still telling ourselves a fairy tale in Glasgow about the tobacco trade. We're still in denial about racism, and that really needs to when that changes how we speak to each other, and power. Who gets to tell the story is a major aspect of racial power.
Tendayi?
I would maybe just add that, you know, when we think about regimes of racial subordination, and when we think about the regime of the enslavement of Africans and the trade in Africans, which was a very complex one, really unpacking the complexities of how those regimes are possible and able to succeed, I think is urgent work, you know, and I think you're right to, in your question, hint that any attempt to mask the complexity of that system, including complicity of, you know, nations in West Africa or wherever it might be, any attempts to kind of mask that undercut the underlying project, I think fully grappling with the regimes requires an honesty in engaging with exactly how they worked and exactly who contributed to what. And I don't think any of that work can ever undercut the claims for reparations that those who suffered those violations ever experienced. I don't think there is any mapping of the complexity of, you know, responsibility that can undercut the underlying claims for reparations. And then when you think about reparations as being about transforming structures, there too, I don't think any attempt to be comprehensive in understanding the way the systems works and how different groups participated will ever mean that the work doesn't remain the same, which is providing compensation to those who suffered the injustices, and then also undoing the structures that persist to this day. So I would say, you know, we must be comprehensive, absolutely, and that kind of comprehensiveness will not undercut the fundamental claims that are made by those who seek reparations.
I think you're right, but what I would say is that it's not so much about undercutting claims. I think it is getting a comprehensive historical picture. It's telling an honest historical narrative, but there's something else. And I'll just use Senegal as an example. You know, Senegal is where the Gorée Island is. You know that they've invested enormously in diaspora return with the African Renaissance Monument, the Museum of Black Civilization, which features largely Blacks from the diaspora. I'm actually the ambassador for that museum, the Gorée Memorial, and other infrastructure they've invested heavily in. See, I see that as an investment back into the diaspora and the greater call for African unity, et cetera. But then there are other questions that I think are worthy of asking, which is, out of 54 African states, has one offered diasporans, African Americans, others, dual citizenship, and what might that look like? Right. There are tangible and intangible ways to kind of look at this question that actually helps solve the greater enterprise that we're in, which is the reparations enterprise, that there's something unique about states with sovereignty and the power that they have to forward an agenda with the diaspora. We haven't reached that place of unification. The work of Du Bois is incomplete. The work of Kwame Ture is incomplete, and so forth. So I'm thinking about it kind of in that way as we think about liability and responsibility and the kinds of conversations we need to be having in the diaspora and inside the continent. So let me ask you this. Both of you are in Los Angeles, attuned to the various issues of reparations. We know in the last presidential election, for the first time in the history of the country, reparations was a subject of presidential conversation. And there were commitments made by the candidates, the administration. There were progressive, claims and statements. Yet HR 40 is still not the subject of conversation in the way that it should be. Do you think that there is some hope with the current administration, and we're looking at this both domestically and globally, to maybe address the issue of reparations in a more comprehensive way, whether it's passing John Conyers' HR 40 or whether it's something else that might lead the nation to a greater sense of its moral responsibility.
So I'll jump in this time first, and then Eric, you can go after me. But to just speak to your previous comment before getting into the answers to this question, Jeremy, I think you're absolutely right, and this is something we don't talk enough about when we're talking about reparations for slavery and also for colonialism, which is kind of when we think about people of African descent and people on the African continent, when we think about African nation states and the ways in which they should be a part of, you know, repairing structures and transforming structures such as citizenship in ways that would be responsive to the harms of slavery and colonialism. I think there is a lot of work to be done along the lines that you're describing, and maybe that's an idea for another ASIL conference, is one that would specifically center some of those dynamics, because I think there's a lot of really, there's amazing potential there, and as you're describing, some of it is already underway. But when it comes to questions about this administration, I mean, I'll tell you what I think honestly. I think there is an opening, right? And this opening is one that is kind of represented in the fact that you can have a presidential discourse around reparations. And I think that there's an opportunity for the federal government in this country and for the Biden administration to really take concrete steps in the direction of moving us towards reparations in this country. What I fear will happen, though, is that there will be some kind of tokenistic intervention that pays lip service, you know, to a move towards reparation, but then misses an opportunity to go as deep as we really need to be going. That's my pessimistic read, but it's conceivable, but that the kind of political mobilization that made it such that it made it, you know, a presidential priority even speak to reparations, it's conceivable that that kind of energy might work to hold the Biden administration accountable. But I am not especially hopeful, because I think too often it can be easy to create commissions, to have interventions that pay lip service to the issue without fully kind of going in the way that we need the administration to go in.
So I'll just quickly say a couple of things. One, the issue of reparations and sovereignty is a deep one, and often the demand for reparations is a demand that goes along with sovereignty, for land, for control, various things that are associated with sovereignty, and so it would be great to have a longer conversation about that. I think it's really important. But the second thing I'll say is, in terms of commissions, California has just set up a reparations task force, and we need to hold that accountable to do the work of not just paying lip service, as Tendayi puts it, but as actually doing hard work. And even with HR 40, even if HR 40 doesn't pass, we can pressure President Biden to form a task force. He's done it to look at the expanding the Supreme Court that can do the work of HR 40 if he wants. So the fact that the Democrats currently hold all three departments of government, may not after 2022, shouldn't stop us. Tendayi says we've got to keep pushing for accountability, and now is definitely the time. The Democrats in Congress are definitely interested in pushing reparations domestically. So let's keep fighting.
Wonderful. We got about 30 seconds left. Tendayi, did you want to have any closing thoughts?
I guess my closing thought would be that, you know, the goals that we've been discussing across this entire conference are really important ones. And I think interventions like the conference itself are not separate from the achievement of those goals. So it's just, I guess, a thank you to the organizers for creating this space, and then a plea that we continue to keep this space open, not just because of the moment that we are in, but going forward, that there will be mainstream avenues to continue to have these really important conversations.
Wonderful. Well, thank you to the both of you. I think those who are participating have had the issues illuminated in a way that perhaps has not been illuminated in this conference or in the past. And To the audience, thank you for joining us on this conversation about the legacy of enslavement, contemporary dimensions, and remedies. You will be able to purchase or review from ASIL the audio recording of this tape, and we thank you for joining us.
Greetings and hello again to those of you who joined us for the day's first session. I'm Chantal Thomas, co-chair of the Symposium Organizing Committee, along with my co-chair Natalie Reed. And I hope that you've been enjoying the day of brilliant, intense, vigorous, important conversations. And it's my great pleasure to introduce to you our keynote speaker, Professor Philippe Sands, who will deliver an address on reparations for and contemporary systemic racism who joined us as a legacy for enslavement. Session. I'm Chantal. Professor Philippe Sands, QC, is Professor of Laws and Director of the Center on International Courts and Tribunals at University College London, as well as the Samuel and Judith Pizar Visiting Professor of Law at Harvard Law School. He is also a barrister and a founding member at Matrix Chambers and the president of the English chapter of the organization PEN, which works to defend and celebrate free expression. In addition to his academic work and publications, Professor Sands maintains an extensive and accomplished practice in general international law and has appeared before many international courts, including the International Court of Justice, the European Court of Justice, the World Trade Organization Dispute Settlement System, the International Tribunal for the Law of the Sea, the International Criminal Court, and the Special Court for Sierra Leone, among others. I could say much more about Professor Sands, but I do not want to keep you any longer from this very special address. Professor Sands, thank you so much.
Thank you, Chantal, and thank you, Judge Robinson, and thank you, the American Society, and all the organizers of this really important conference, which I'm happy and very privileged to be a part of. I've been asked to address contemporary systemic racism as a legacy of historic enslavement and the extent to which it breaches international law and gives rise to a right to reparations. We all know these are complex and painful matters, and they touch each and every one of us, and they give rise, I think, to a personal responsibility to engage. I've been, as Chantal mentioned, very privileged to be involved in matters of international law across 4 decades now. And I have to say, on the basis of my own observations and experience, I have come to the view that racism against Black people has been and continues to be endemic in the current international order. I see that, for example, on the website of the International Criminal Court. All 30 cases of indictments involve Black men from Africa, a group of human beings who do not have a monopoly on international crime. I see it amongst my colleagues in legal practice. So few of my co-counsel in international litigation are Black. Across 15 years as an arbitrator in dozens of investor-state disputes involving different countries, and I've got to say, I say this with a deep sense of embarrassment, I have never once sat with a co-arbitrator who is Black. While I'm not in a position to say with any degree of certainty how this situation has come to be, intuitively, it seems to me that it cannot be entirely disconnected from the legacy of enslavement. Let me go even further. It's really only relatively recently that I have truly started to reflect on all these matters. I grew up in a country, Britain, in which my education bypassed matters of slavery, colonialism, and race more or less entirely. As a schoolboy, I remained unaware of such matters. Classes at school offered a particular account of British colonialism. Preparing this lecture in our attic, I found my old school history book from 1973 and read once again the chapter which was wistfully entitled Sunset on the Empires. On India, for example, we were taught about Britain's last viceroy, a remarkable man, the book told us, a man who compared favorably to the new leadership of Mahatma Gandhi. And I kid you not, and I quote, wizened, bony, almost monkey-like, a leader with cheap spectacles, a vegetarian, a pacifist. On the end of empire, we were taught that the relationship between colonizer and colonized could be understood as being akin to the relationship of parent and child, one in which the parent never admits that the child is quite grown up, the child rebelliously insists that it is, the child usually gets its way in the end, and learns, sometimes painfully, by its own mistakes. That's a quotation, not me speaking. Matters did not improve markedly at university, I now realize with the benefit of hindsight. My teachers of international law were very marvelous in many ways, but they were all white men. Some had been retained to give advice to newly independent countries of Africa, somehow leaving the suggestion that this might be an aspect of our social function going forward if we entered the world of international law. When did the scales really start to fall from my eyes? It was a gradual process, but it's only relatively recently that I think I've come fully to see the world as it really is. In 2010, I was retained to advise the government of Mauritius on litigation to recover a part of its territory, the Chagos Archipelago, that it considered to have been unlawfully dismembered by the British government in violation of the principles of self-determination and territorial integrity. In the course of that engagement, I learned firsthand of the fate of a community known as the Chagosians, the 2,000 or so inhabitants of the islands, many of whom were descendants of enslaved people brought in from Mozambique and other parts of Africa. Every single one of them was removed from their homes and their islands between 1968 and 1973, and they were transported to Mauritius, the Seychelles, or Crawley, a town on the southern outskirts of London. The matter reached the International Court of Justice a couple of years ago, following a request for an advisory opinion from the General Assembly on whether the decolonization of Mauritius had been completed in accordance with international law. In preparing our arguments for the court, the oral hearings, we did think it was of the utmost importance that the judges must hear directly from the Chagosians. And so witness testimony was provided by Madame Lisby Elise. She was 20 years old when she was forcibly removed from her home and island in the spring of 1973. She recalled in our statement to the court being told to leave at short notice, boarding a ship in the dark in terrible conditions. We were like animals and slaves in that ship, she told the judges of the International Court just a couple of years ago. How terrible, I'm sure everyone felt, that a descendant of enslaved people was describing her own treatment as though she too was enslaved. The British government defended itself. It offered words of apology for its shameful actions, but nothing more. The British arguments failed. The court determined that the separation of Chagos was unlawful, that Chagos was and had always been a part of Mauritius and still is today. In May 2019, the General Assembly adopted the opinion and ordered the United Kingdom to leave Chagos by November 2019. It recognized the right of the Chagosians to return. After the vote at the General Assembly, which Britain lost, as the New York Times put it, in an embarrassing fashion, the British ambassador took the floor and she dissembled. Britain remained committed to self-determination, she said, if not for Mauritius or the Chagosians, then most certainly for the inhabitants of another distant colonial possession. In her words, as she said, no dialogue on sovereignty until the Falkland Islanders so wish. And as I listened to her, I thought, what is the difference between the 2,000 Falkland Islanders, the islanders of the Malvinas, entitled to the right of self-determination, and the 2,000 Chagosians who are not? There is no escape from the one obvious distinguishing feature of the two communities. One community is white, the other community is black. And having just watched the last wonderful panel in this conference, I have to say, listening to what the Biden administration is doing and what it might yet do, the Biden administration has the power to allow the Chagosians to return. And I hope each of you will take up this point, and the American society too, and put it on its agenda. Linda Thomas Greenfield, the ambassador at the UN, Antony Blinken, Secretary of State, Jake Sullivan, National Security Advisor, Kamala Harris, they can all make it happen if they want to make it happen. Over the years, I've come to know Lisby Elise. We've become friends. Sometimes I ask her about the compensation that she was paid, the reparation for being forcibly removed. And she mentions embarrassingly small amounts. 7,590 rupees in 1978, 10,000 more in 82, 3,000 more in 83, 36,000 more in 84. That's it. What's the sum in British pounds sterling? 3,600, about $5,000. the compensation for the loss of a home, a livelihood, a life, and no compensation was ever paid to any member of her family for the enslavement of her ancestors. But compensation was paid to those who owned her enslaved forebears when slavery was prohibited on the islands of Chagos by the British. Sometime around 1830, about £865, 6 shillings and 9pence, that's about £60,000, nearly $100,000 in today's currency, was paid to a Louis-Jean Baptiste Bayeux for the loss of 28 enslaved persons he owned on Diego Garcia, the largest Chagosian island. Many of you will know it today as the location of a major US military base. On the same island in 1837, £46, 19 shillings and 9pence, about £3,000 today, was paid to Adèle Garot for the liberation of a single enslaved person. And £1,584, that's over £100,000, $150,000 today, was paid to an Ozil Majastre for the loss of 52 enslaved persons. Many thousands of others were paid compensation for the loss of enslaved persons, and the benefits of those payments continue to accrue to this day. One such person is Richard Drax, a Conservative member of the Westminster Parliament for the constituency of South Dorset in England. He's a multimillionaire. He's inherited various properties, including the 250-hectare Drax Hall sugar plantation in Barbados. The CARICOM Reparations Commission has described the plantation as a killing field and a crime scene, a place where tens of thousands of enslaved African persons died in terrible conditions between 1640 and 1836. The Commission has made demands for reparations, so far without success. This plantation made the Drax's family's fortune and no doubt has assisted successive generations of the Drax family to be able to represent Dorset in the British Parliament. Curiously, Mr. Drax's voting record doesn't appear to reflect a particular inclination to take account of his own past or to promote laws on equality and human rights. Just a few years ago, he voted to end the obligation of the United Kingdom Commission for Equality and Human Rights to develop a society in which people's ability to achieve their potential is not limited by discrimination. In 1998, he voted to repeal the Human Rights Act. In the wake of the Black Lives Matter protests last year, he published an editorial in his local newspaper, the Dorset Echo, deploring the wave of intolerance that supposedly swept Britain following the abhorrent killing of George Floyd. The need to respect issues of discrimination, he wrote, must not undermine our way of life. Madame Élisée of Chagos and Mr. Drax of Dorset have rather different ways of life. She has not benefited from any reparation in relation to her forebears' enslavement. Meanwhile, he benefits not only from the accrued wealth through slave labor, but also from the substantial sum, nearly £300,000 in today's values, that his family was paid as reparation for the loss of 189 enslaved persons back in 1836. This reality reflects the lives of many others. In Britain, where I live and from where I'm speaking this evening, nearly half of all Afro-Caribbean families live in poverty, compared with 1 in 5 white households. Young Black men in Britain are twice as likely as other people to die from the use of force by police officers. Yet as recently as March 2021, just a few weeks ago, the report of the United Kingdom government's Commission on Race and Ethnic Disparities, commissioned by this Conservative government, simply glossed over these disparities. The preface written by its chair asserted that the British experience, and I say this with deep embarrassment, and I quote, speaks to the slave period not only being about profit and suffering, but how culturally African people transform themselves into a remodeled African Britain, end of quote. In a way, the history of Drax family mirrors a larger narrative of how enslavement led to an intergenerational transmission of unjust enrichment and unjust impoverishment, one that has lasted over 2 centuries and has been facilitated by consensus in some parts of society to accept inequity as a given. Unsurprisingly, such factors have perpetuated social hierarchies along racial lines. In the US, data from historical census records indicates that white populations in places that relied more heavily on slave labor experienced better social and economic outcomes than white population in places that relied less on slave labor. Another study, combining census data with sociological surveys, reports that whites who live in counties which had high concentrations of slaves in 1860 tend to be more conservative and express colder feelings towards African Americans than whites who live elsewhere in the American South still today. It may be reasonable to conclude that dismantling the legal apparatus of slavery has not eliminated the racial attitudes that accompany, justify, and solidify what one academic has called the unjust, deeply institutionalized, ongoing intergenerational reproduction of whites' wealth, power, and privilege. As many of you will know, these matters are addressed in the literature, books like The New Jim Crow, Michelle Alexander's remarkable work on racial discrimination's impact on mass incarceration. With increasing recognition of the extent to which such systemic racism is rooted in historic enslavement, calls for redress understandably grow louder. There have been attempts at reparation, whether monetary or symbolic, in many countries over the years, but with only limited success. In 1865, during the American Civil War, a wartime order indicated that all freed slaves would be compensated with 40 acres and a mule, but that was later reversed. The idea of reparations was raised at the 2001 UN World Conference Against Racism in Durban, but it was left out of the final declaration. That merely noted that, and I quote, the transatlantic slave trade was among the major sources and manifestations of racism, racial discrimination, but no remedy was broached. Mauritius itself constituted a Truth and Justice Commission in 2009 to make an assessment of the consequences of slavery and indenture labor during the colonial period up to the present. That government's commission recommended that the government seek funding from historical slave trading nations, such as the United Kingdom and France, for the rehabilitation and reconstruction of communities and settlements where slave descendants are in the majority. But those recommendations are yet to be acted upon. Historic injustices on this scale across continents, affecting hundreds of millions of human beings, are too complex to be dealt with by the institutions of any single country. The UN Special Rapporteur on Contemporary Forms of Racism, Professor Tendayi Achiume, and what a pleasure it has been to just listen to you just now, Professor, observed in her 2019 report that slavery and colonialism were global projects and reparations for both require global intervention, that UN member states should create a platform devoted to the serious consideration of reparations. Such an international platform would serve the useful function of offering a historic record, clarifying what happened and what have been the consequences, and it could also reach factual and then legal conclusions as to how those consequences might best be addressed. A Global Truth and Reconciliation Commission could be one way to address this need. Such commissions are grounded in law, but unlike adjudicatory bodies, may walk the intersecting lines of law, justice, and reconciliation. Another alternative mechanism could be an international fact-finding mission like the recent UN investigative mechanism on Myanmar, which could offer assistance to bodies like the International Court of Justice or the Permanent Court of Arbitration. I'm counsel for the Gambia in the case against Myanmar involving the mistreatment of the Rohingya, and but for that reports of the UN investigative mechanism, it would have been much more difficult to mount a case. Whatever path is taken, it seems to me that three factors at least are going to have to be addressed. And I suppose I'm speaking here in part as an international litigator. First, it will be necessary to establish a causal link between historic enslavement and contemporary racism. Second, it will be necessary to tie such a causal connection to a violation of international law, giving rise to an obligation to make reparation, irrespective of whether the original act, enslavement, was internationally unlawful when it occurred. And third, to the extent that a legal obligation arises, it will be necessary to determine whom, to whom, from whom, and in what manner reparations might fall to be paid. Some will say that existing international legal principles are inadequate to deal with the challenges. The law is insufficiently decolonized, imaginative, or robust. I disagree. The law does offer a route. The question is more one of a political will. And it's to these points that I now turn. So let's begin with the key question of causality. Is there a link between historic enslavement and contemporary racism? The Committee on the Elimination of Racial Discrimination, which oversees the implementation of the 1965 Convention, considers that there is. Its General Recommendation 34 noted that racism and structural discrimination against people of African descent, rooted in the infamous regime of slavery, are evident in the situations of inequality affecting them. The committee's conclusion is consistent with the view of the Working Group of Experts on People of African Descent, which has made annual visits to many multiracial countries that were involved in enslavement or the transatlantic slave trade. In the report from its most recent country visit, for example, Peru, the working group has noted the significant decline in the socioeconomic status of Afro-Peruvians, despite broader economic developments in that country. Such conclusions indicate a connection between historic enslavement and contemporary racism. So let's reflect on various aspects of that connection. How does one begin to identify the indicia of causality? Let's start with money and wealth. One noticeable disparity between the descendants of the enslaved and those of slave owners is, of course, in relation to wealth. The Drax family's current wealth is constructed on the foundations of the unpaid and later on underpaid labor of persons of African descent. The intergenerational wealth benefits to white communities can also be indirect. In the US, demographic projections indicate that millions of white Americans are descendants of those whites who received millions of acres of public lands allocated by the government during the era of slavery. Even after the abolition of slavery, extensive racial exclusion and violence directed at African Americans meant almost all who gained access to the wealth-generating resource that is land were white. Numerous studies suggest that nearly 50 million white Americans may be descendants of families who benefited in this way. Relatedly, racially restrictive covenants of the early 20th century barred the sale of property to African Americans. This, coupled with predatory lending practices and redlining, effectively denied property ownership to Black communities. There are other ways too in which white communities limited the ability of Black communities to retain property and pass it on to future generations. Just a few weeks ago, I listened to a remarkable episode of Unfinished, Deep South, a very affecting podcast, I have to say, that tells the story of Isidore Banks, a wealthy African-American farmer who was lynched in 1954. Mr. Banks had owned more than 1,000 acres of land along the Arkansas Delta until his rights disappeared immediately in the period following his death. Similarly, there's plenty of evidence that in other countries, such as Brazil and Peru, the inability to obtain official titles to land has resulted in generational losses of property owned by Black communities. Far from being ameliorated, there's ample academic research to suggest that these and other historic financial disadvantages have been entrenched and deepened by current economic policies. As one writer has put it in relation to matters monetary, the real legacy of slavery is not Black deficits, but white racism. I turn to slavery and health. Access to healthcare is another indicator of racial disparities. Access to preventative healthcare has long been shown to be linked to social class, leading to higher morbidity rates among Black populations. Even independent of income, race can have a devastating impact on the quality of diagnosis and treatment. Studies show that a slavery-era stereotype of Black people's supposed higher pain threshold is associated with undertreatment for pain, and that this may be one of the causes of higher Black maternal mortality rates in the United States. Incredibly, as recently as 2016, a study by the US National Academy of Sciences reported that 29% of white first-year American medical students thought that Black people's blood coagulates more quickly than white people's, and 21% believed that Black people have stronger immune systems. the Academy found a link between such misperceptions and inadequate preventive care and inferior treatment. And of course, not surprisingly, in these difficult times, the current COVID-19 crisis appears to have had a disproportionately negative impact on Black communities. In its 2020 report, the UN Working Group of Experts notes that measures have not been taken to counteract the foreseeable risk to persons of African descent, despite existing inequalities in health. At this point, the data remains limited, but where available, it is deeply troubling. In the US, African Americans have experienced triple the rate of infection and nearly 5 times the rate of hospitalization and twice the rate of death compared with white Americans. In the United Kingdom, people of African descent were at least 4 times more likely to die of COVID-19 than white people. In both countries, triaging and do not resuscitate orders are said to have been inappropriately used in the case of people of African descent. I turn to slavery and trauma. In addition to physical health, there is growing evidence as to the psychological and mental health impacts of living through racism. Intergenerational trauma is a subject I'm keenly interested in. I opened my book, East-West Street, with a quote from 2 Hungarian psychoanalysts, Maria Torok and Nicholas Abraham. What haunts, they wrote, are not the dead, but the gaps left within us by the secrets of others. And I think these words are equally pertinent for the subject of this important conference. Psychological studies have confirmed that experiencing or witnessing racial discrimination or violence causes trauma and anxiety disorders. Recent research is showing that such trauma can also affect descendants of those who experience the event firsthand at a psychobiological level. Domestic violence victims, Holocaust survivors, and descendants of the enslaved are groups in which transgenerational effects are beginning to be understood. Epigenetics, the study of how behavior and environment can cause changes that affect the way our genes work, is also a growing field. And there's scientific evidence to suggest that poor conditions and stress, especially prenatal stress, endured by enslaved people, may have had an impact on their bodies and those of their children, inherited in turn by their descendants today. To avoid engagement with the consequences of trauma is to risk generations of Black people paying the physical and mental health price for the ill treatment of their forebears. Turn to slavery and justice. In recent years, much attention has been given to the evidence that Black people face significantly harsher outcomes in the criminal justice system of most multiracial countries. This is described, as I've already mentioned, in Alexander's The New Jim Crow. Despite a justice system that is supposed to be colorblind, African Americans disproportionately find themselves in prison and later as ex-offenders with restricted access to social welfare and even the right to vote. In Alexander's words, mass incarceration in the United States acts as a comprehensive and well-disguised system of racialized social control that functions in a manner strikingly similar to Jim Crow. Slavery-era stereotypes of criminality and aggression often lurk behind profiling and custodial violence suffered by Black individuals at the hands of law enforcement. One need only think of George Floyd, and inform heightened degrees of guilt and harsher sentences. The situation recalls the state-sponsored violence and unfair judicial practices that controlled enslaved populations and in due course victimized Black communities after enslavement's formal end. The legacy of slavery appears also to have influenced education. As in the case of my own schooling, it's plain that the educational curriculum in many modern multiracial nations fails adequately to address these countries' role in colonization, enslavement, and the slave trade, or the impacts on persons of African descent. Equally, textbooks fail to mention Black achievements and contribution to the modern nation. This is in some cases made worse by the perpetuation of certain racial stereotypes. In some countries, schools still recapitulate colonial propaganda, such as, for instance, the suggestion in Belgian school textbooks that economic development came to Africa as a result of colonization. That's a quote. Such discourse undoubtedly plays a part in encouraging notions of white superiority. The UN Working Group of Experts on People of African Descent has noted that explicit racial discrimination and the use of colonial-era slurs continue to traumatize young Black students at schools, with serious implications on learning. Stereotypes about Black students' scholastic ability leads to discriminatory assessments and poor quality career and higher education guidance. The working group notes that their consequent underperformance in tests is not scrutinized in the same way as if a test eliminated most or all white students from consideration. By way of conclusion, this brief review underscores some of the myriad ways in which a Truth and Reconciliation Commission or process, or maybe a judicial body, could assess the legacies of slavery as a matter of fact-finding, as reflected in the systemic racism of contemporary institutions. Establishing this causal link is a necessary prerequisite to allowing inquiry to progress to the next question. And that is, to what extent it's arguable that contemporary racism rooted in historic enslavement might be said to give rise to a violation of international law. The prohibition of racial discrimination is deeply etched into international law today. Article 1.3 of the UN Charter calls for respect for human rights and for fundamental freedoms for all, without distinction as to race. Articles 4 and 7 of the Universal Declaration of Human Rights reinforce the prohibition of slavery and discrimination. The International Covenant on Civil and Political Rights and on Economic and Social Rights affirm that human rights obligations must be undertaken without discrimination on the basis of race. And of course, we have the Convention for the Elimination of All Forms of Racial Discrimination. Arguably, the conditions of life created and perpetuated by systemic racism violate other human rights. Disproportionate rates of detention and custodial injury of Black people and countless instances of excessive force used by law enforcement may be said to violate the right to life, and prohibitions on torture or arbitrary detention, as well as the right to equality before courts, all rights guaranteed by the ICCPR and, in my view, by general international law. Systemic racism has resulted in deep-rooted social inequalities that violate other rights, including the right to work, adequate standards of living, physical and mental health, and education, all guaranteed by the ICESCR. 2 centuries nearly have passed since the abolition of slavery, yet there remains a persistent gap in the degree to which these social and economic rights have been realized for so many of African descent. But in trying to bring contemporary racism within the scope of international law, we have to recognize that certain challenges exist. To grasp the gravity and the scale of these offenses and ensure commensurate reparations, it's necessary to see them in their transgenerational context as the legacy of historic enslavement. The intertemporality of such a claim to reparation does give rise to challenges. Can today's consequences of historic acts in relation to enslavement engage a liability for reparation, irrespective of whether the original act was unlawful at the time of its occurrence? The conventional view holds that the international consensus against slavery emerged only in the 19th century, leading to a rule of customary law by about 1885. In the 20th century, the prohibition has come to be recognized as jus cogens. And thus, for a large part of the period during which transatlantic slavery took place, it was not explicitly unlawful at national or international levels. And judges faced with the issue will have to address whether the later consequences of enslavement in the form of systemic racism can be considered to violate international law. A number of considerations may here be pertinent. To begin, there continues to be discussion as to whether the norm against slavery might have emerged in international law even before its formal establishment in all countries. One view posits that although not yet a rule of custom, transatlantic slavery violated general principles of international law as derived from the vast majority of national, regional, and communitarian legal systems of the period. But that view is not widely shared. Nevertheless, I do not believe that international law entirely discounts the possibility of legal accountability for the illegal consequences today of long ago acts that may have been lawful. a truth commission or court facing the issue of reparations may view enslavement and consequent systemic racism as a continuing violation of international law. The key factor distinguishing this claim for reparations is that neither the wrongful act itself nor its harmful consequences are discrete events that occurred or were completed at some moment in the past. If contemporary racism is indeed a direct legacy of enslavement, the wrong itself may be said to continue long beyond the date of its formal abolition. If its impact on the lives of Black people is indeed reinforced with every passing generation, it appears that the consequences continue to be felt to this day. Article 14 of the ILC's articles on the responsibility of states for internationally wrongful acts, recognized by the General Assembly to be reflective of custom, states that the breach of an international obligation requiring a state to prevent a given event occurs when the event occurs and extends over the entire period during which the event occurs, continues, and remains not in conformity with that obligation. An example of such a continuing wrong is stated as being the maintenance in effect of legislation incompatible with the state's international obligations. While these ILC articles don't directly address the implication when the event commences prior to the coming into force of the rule against it, national and international courts have considered the matter. In 1999, for example, in the case of Senator Pinochet, I was involved in proceedings before the English courts premised on the continuing consequences, disappearance as an act of torture, of acts originally occurring before they had been internationally criminalized, or in respect of which the court's jurisdiction only arose at a much later date. The Special Court for Sierra Leone prosecuted crimes of forced marriage, despite the incidents having initially occurred prior to the time period covered by the court statute, as they were continuing crimes, ongoing during the indictment period. That court similarly prosecuted the recruitment and training of child soldiers that had commenced in 1991, even though it considered this prohibition to have definitively crystallized into an international crime only by 1996, due to the fact that the crimes had continued into the relevant and current period. The extraordinary chambers in the courts of Cambodia too, in prosecuting a joint criminal enterprise, considered certain acts of planning and devising that occurred prior to the beginning of its temporal jurisdiction, since it concluded it would be unnatural to break up such a protracted and complex transaction, as it is only intelligible if all of its components are considered together. And of course, having written East-West Street, I often think about Hans Frank, who was Adolf Hitler's personal lawyer from 1928 to 1933, as he sat in the dock 75 years ago and was presented with his indictment for crimes against humanity and genocide in relation to acts in which he was involved between 33 and 45. Those two crimes were only invented in 1945. In a similar vein, an adjudicating body could address systemic racism rooted in enslavement, irrespective of having originated prior to formal legal prohibitions against enslavement, in my view. Moreover, I think there may exist a moral imperative compelling states to agree upon the retroactive application of contemporary international law to cover the present-day consequences of an act such as this, which, irrespective of its legality at the time, shocks the conscience today. That's sort of the Nuremberg principle. In international law, the rule against retroactivity cannot be said to have been applied with absolute consistency in the face of acts considered to be of serious scale and gravity. Nuremberg and the tribunals for the ex-Yugoslavia and Rwanda were all created after the fact and prosecuted mass atrocities on the basis of statutes codified after the occurrence of these crimes. Slavery has been perceived as a crime of similar gravity, at least from the 20th century onwards. In 1933, for instance, Raphael Lemkin, the remarkable Polish lawyer who coined the term genocide, sought to establish its gravity by likening it to slavery as an offense universally punishable due to humane principles. And of course, more recently, slavery has been characterized as a crime against humanity. The emphasis in adjudicating such crimes has been as much upon a doctrinal basis in law as upon a growing moral consensus against the acts that occurred and possibly also their continuing effects. As Henry Stimson, the then US Secretary of War, put it, the Nuremberg tribunal's coming into being was not a trick of the law, it was the massed, angered forces of common humanity. In a 1975 resolution of the Institut de Droit International on intertemporality confirmed that states have the power to determine by common consent the temporal sphere of application of norms. If there is a political will to mobilize the law to address the transgenerational consequences of enslavement in the form of contemporary systemic racism, there should also be a way to do it. Even if a court or truth commission were to find the intertemporal issue difficult to surmount, there is always, of course, the doctrine of unjust enrichment, Mr. Drags, which exists in many domestic legal systems and is considered by some to be a general principle of international law. This too can offer another avenue. The principle applies where conduct may not be internationally wrongful as such, but nevertheless leads to one entity being enriched at another's expense in a way that the law regards as unjust. Restoring a part of the continuing unjust gains of the beneficiaries of slavery and systemic racism, as quantified by reference, for example, to contemporary racial wage gaps or historical profits, may restore some disadvantages, even if more comprehensive moral reparations remain lacking. This is, however, an incomplete solution, and there is the danger, as some have noted, that it would reduce the grossest of human rights violations to an outstanding bill for services. For this reason, perhaps, the approach ought only to be entertained in conjunction with the other approaches to the resolution of historic and continuing injustices. Turn to the third part of my analysis. If a truth commission or court were to find that a breach of international law had occurred, it would have to address this third element, namely the nature of reparations owed. Under customary international law, it's long established that where an illegal act occurs, a right to reparations follows. In 1928, the Permanent Court of International Justice made clear that reparation must, as far as possible, wipe out all the consequences of the illegal act and re-establish the situation which would, in all probability, have existed if that act had not been committed. The codification of the law of state responsibility adopts this approach, allowing reparation to encompass restitution, compensation, and satisfaction in the form of an acknowledgement of the breach, an expression of regret, a formal apology. To this, the UN Basic Principles and Guidelines on the right to a remedy and reparation for victims of gross violations of international human rights law adds as a best practice some form of rehabilitation. Insofar as restitution is concerned, the long-running and continuing nature of the harms makes it difficult to envisage the situation that would have existed but for the practice of enslavement and consequent systemic racism. The first step may involve institutional reform within multiracial nations to account for the needs of African descent populations, with specific attention to issues like social welfare, and reform of laws to make them fit for purpose by undoing the legacies of historical racial discrimination. In Britain, in the kind discussions of Windrush, this is a very real issue right now. And it may also be necessary for these states to actively counteract racial stereotyping and ensure that public discourse regarding the history of enslavement and colonization is more complete and accurate. Allocating funds for research, bias training, awareness programs could go some way towards achieving these ends. I've read with interest the CARICOM 10-point plan for reparatory justice, which sets out a number of ideas for the steps that former slave trading nations may be required to take. It calls for European governments whose nations were responsible for enslavement and a further 100 years of racial apartheid to invest in health, education, technology, and cultural institutions of the Caribbean countries to which they forcibly transported the enslaved. In addition, states may find themselves in the position of having to pay compensation to their African descent populations, for the extent of injuries that restitution cannot repair. This could be proportionate to the current wage gap between white and black populations, a gap that was estimated at $154,000 per year between median black and white families in the United States in 2016. And it may also be necessary to compensate black people for the costs attached to being the targets of racial oppression, including the dramatic loss of time and energy from having to cope with discrimination, damage to health, and harm to families and communities over the course of generations. Institutional reform and monetary compensation can never fully account for the lived experience of racism and disadvantage. States will also surely be called upon to consider principles of rehabilitation for the descendants of enslaved communities. For instance, the provision of medical and psychological care, as well as legal and social services, to help combat the extensive mental health impacts of racial discrimination. And finally, it will surely be necessary to offer some formal manner of recognition or apology for the continuing scourge of contemporary racism and the fact of its being linked to historic enslavement. So I turn to some brief conclusions. The path to reparations is long and it undulates. Most countries have done little to engage with their own historic wrongs or their continuing effects in our times. External prompting is needed, including by international efforts, to place a spotlight on past wrongdoings. I think in this way, international law can and does have an important role to play. This is particularly the case in my own country, Britain, as its colonial past continues to haunt, with greater focus placed on the country's role in the abolition of slavery than in its application over centuries. The toppling last year in June of a statue of Edward Colston, merchant, philanthropist, Tory parliamentarian, owner of the enslaved, and its dumping into the harbour of the city of Bristol is seen by many as marking a possible turning point. But of course, the event has given rise to a backlash, including in the recent report on racism commissioned by the British government and published in March 2021, which I mentioned at the beginning. The report seeks to highlight the immigrant optimism, as it puts it, of some new African communities, in contrast to their Caribbean peers, who are said to sit in the same classrooms, offering proof, it is said, that it is, and I quote, difficult to blame racism in education for the latter's underachievement, end of quote. For the writers of this report, it is anathema to suggest that modern racism is somehow connected to the legacy of enslavement. Instead, this recent report opts to focus on geography, family influence, socioeconomic background, culture, and religion as having more significant impacts on life chances than the existence of racism. And, it might be said, anything but a reference to enslavement. This stands in stark contrast to data from international bodies and the lived experiences of generations of Black people. In relation to the subject I'm addressing, it's striking that slavery gets just one mention in the report, and that is only in the preface. That is the terrible line by Dr. Tony Sewell that I mentioned at the beginning. His line has drawn in recent weeks, since it was published, extensive critical comment, and it has unleashed in Britain a backlash against the backlash, forcing Dr. Sewell to offer a clarification, a footnote, in which he explains that his intention was simply to indicate that in the face of the inhumanity of slavery, African people preserved their humanity and culture. But the report is totally silent on slavery's impact on life today. And that silence, as I read it, caused me to reflect once more on the life of my friend, Lisby Elise, and her fellow Chagossians. As they wait to return to their homes on the Chagos archipelago, a matter of when rather than if, in my view, as the British government refuses to recognise decisions by international courts and the UN, they may not be immediately aware of these distant tales of past wrong. They have, after all, more recent and continuing injustices to contend with. Seen in a broader perspective, however, their treatment, informed by the gross mistreatment of their forebears, is surely inseparable from the long chain of events that led up to it. That is my clear view. Ancestors were forcibly transported to Chagos as slaves. None received reparation for their enslavement, even as their white slave owners were compensated for the loss of their properties. The symmetry is a bleak one. A Chagossian community that was forcibly removed from homes, followed by the payment of meager compensation as their lands were repurposed for Western defense purposes. And yet, as ever more thought is given to the subject of this conference, which seems to me so very timely, new possibilities do emerge, with international law potentially playing a pivotal role. 10 years ago, when I first started to work on the Chagos case, I remember a meeting at the US Department of State when I was told by decent folk that the legal arguments that I and Mauritius were hoping to make were hopeless. It turned out that they were not hopeless. They were right, and they succeeded with the judges of the International Court, including Judge Robinson. Nor are they in relation to the identification of a causal link between the conditions of today and the crimes of the past, or the capacity of international law to find a means to build a bridge between the two and to offer a new and more just path forward. I don't think international law is hopeless. We just have to keep ploughing on. Can I finish by thanking my young colleague Ashrutha Ray for her fantastic assistance to me in writing this paper, and to thank you all for your very kind attention. It's late on a Friday night in London, although I know it's only mid-afternoon in Jamaica, and boy, do I wish I was with you in Jamaica. Thank you so much for listening.
Thank you so much, Professor Sands, for that thought-provoking address. That was truly wonderful, and thank you so much. We are going to move to a brief break. We're going to take 5 minutes, and we'll meet back here at 17 past the hour. We will hear concluding remarks and final observations from Judge Patrick Robinson. Thank you again for that address, and thank all of you as well for being here with us. See you shortly.
Greetings.
Go ahead, Natalie.
Greetings once again to everyone joining us for the final session in our two-day symposium on the reparations under international law for the enslavement of African persons in the Americas and in the Caribbean. It is my great pleasure to introduce once again Judge Patrick Robinson, an extremely distinguished international jurist by any measure. He is a pioneer, a model, and a mentor for generations of international lawyers from the Caribbean, like me, and lawyers of African descent around the world. Judge Robinson is currently serving his second consecutive term as honorary president of the American Society of International Law. It is in this capacity that he has conceived of and convened and driven this symposium, drawing together scholars and practitioners from practically every continent to join in these 2 days of analysis, debate, and discussion. It is therefore only fitting that our final presenter will be Judge Robinson himself. First, we will hear Judge Robinson's substantive presentation entitled The Ascertainment of a Rule of International Law Condemning Transatlantic Chattel Slavery, in which he will set out his reaction to the statement in Oppenheim's international law that at the beginning of the 19th century, customary international law did not condemn slavery and the slave trade, and his view that in his submission, on the contrary, there was in fact a rule of international law condemning transatlantic chattel slavery throughout the entire period, preceding and into the 19th century. Judge Robinson will then close the symposium with final remarks. So with pleasure and recognition of the privilege of having played a role in organizing this symposium that, as ASIL President Catherine Amirfar said at the outset, has been the brainchild of Judge Robinson, I pass the mic to you, Judge Robinson, and give you the floor.
Thank you very much, Natalie. Ladies and gentlemen, the well-known 8th and 9th editions of Oppenheim's International Law, Volume 1, Peace, address the question whether customary international law condemned slavery. The 9th edition corrects the omission in the 8th of a reference to the historical period to which its conclusion relates. And this is what the 8th edition said. It was difficult to say that customary international law condemns the institution of slavery and the traffic in slaves. The time dimension is of the greatest importance in an analysis of the wrongfulness of transatlantic chattel slavery. Notwithstanding the correction, Oppenheim's analysis in the 9th edition is cursory and lacking in depth. The 9th edition simply states that, and I quote, at the beginning of the 19th century, customary international law did not condemn the institution of slavery and the traffic in slaves. It arrives at this conclusion without carrying out any examination of state practice prior to the beginning of the 19th century. Such an examination is necessary if one is to determine whether customary international law condemned slavery, whether at the beginning of the 19th century or indeed at any other time. Ladies and gentlemen, the first task in examining whether customary international law condemned slavery at the beginning of the 19th century is to isolate precisely the subject matter of the inquiry. The concern is not with slavery simpliciter, but rather with transatlantic chattel slavery. It is the chattelization of West Africans through transatlantic slavery That is the subject matter of the inquiry. The failure to distinguish transatlantic chattel slavery from other forms of slavery undermines the conclusion arrived at by the 9th edition. The incidents of transatlantic chattel slavery, which stripped West Africans of their personhood, were as unknown to West Africa as they were to England. Indeed, it is very likely that they did not exist in Europe. Now, there were many forms of servile labor in Europe and in West Africa, but they did not rise to the level of transatlantic chattel slavery, which was different not only in degree, but in kind. In the early days of chattel slavery, and even before that time, there existed the practice that a person captured in battle became a slave of the victor. And for this, you can see the submission of Counsel Mr. Wallace in the Somerset judgment that I will refer to later. He said, the right of a conqueror was absolute in England and in Africa. That kind of slavery was totally different from transatlantic slavery. Although the view has been expressed that the Ottoman Empire had a system of chattel slavery, state slaves often occupied positions of great eminence. Thus, the Turkish Sultan Suleiman the Magnificent, the legislator, made Ibrahim Pasha, who had been captured and was a state slave, the Grand Vizier, rather like a prime minister of the Ottoman Empire after he had converted from Christianity to Islam. Other slaves in the Ottoman Empire worked in several areas of national life, such as trade and agriculture, and were treated more like serfs. And as Nora Whitman has stated in her paper, servile labor was also akin, servile labor in Africa was also akin to serfdom in Europe. And I cannot resist telling you this little story from Nora's paper, which illustrates the difference between African slave society and transatlantic chattel slavery. A master requested the Banamba in Mali to provide him with millet. The elder spokesman of the Banamba slave told the master that the millet belonged to them, saying, "We will not sell it today. We have given you the part that belongs to you, because you are our master, but you shall not get more until the next harvest." Ladies and gentlemen, I cannot imagine any enslaved person in the Americas or the Caribbean daring to address a slave owner in that way. Now, the 9th edition would have to be clear as to what constituted the international wrong of transatlantic chattel slavery. The essential feature of a chattel is that it is movable property, in contradistinction to land or other forms of real property. And the movability of West Africans was very evident in the process of their chattelization that had 6 phases. They were transported or moved from West Africa against their will to the Americas and the Caribbean, a distance of some 5,000 miles. And it is their treatment as property or things that explains why they could be moved about so readily and over such long distances. The chattelization of West Africans through enslavement commenced in West Africa on their capture and sale, followed by their forced trek to and detention in slave castles, their transportation packed like sardines in the hulls of ships for a voyage of thousands of miles to the Americas, their sale as slaves there, and finally, their unpaid labor on plantations for years. It may have been a blessing in disguise that the average life of a West African, after being sent to work on the plantations, was no more than 7 years. Ladies and gentlemen, every phase of transatlantic chattel slavery was wrongful conduct. It was not the sale of West Africans in the Americas and the Caribbean that made them chattel slaves. They were chattelized into enslavement upon their capture and sale in West Africa, and continued to be chattelized through every phase, leading to their brutal treatment on the plantations in the Americas and the Caribbean. Had the 9th edition examined state practice, it would have found material on the basis of which it could conclude that chattel slavery was not permitted in England, and quite likely also in France and other European countries. Permit me a comment, ladies and gentlemen, on the famous Somerset case, decided in 1772 in Britain. Mr. Somerset was enslaved in Virginia to Mr. Stuart. Mr. Stuart took him to England. He escaped. Mr. Somerset was recaptured, and Mr. Stuart had him detained on a ship to be transported to Jamaica to be sold as a slave. With the help of Mr. Granville Sharp and other abolitionists, an application for a writ of habeas corpus was filed on behalf of Mr. Somerset. Although it is generally accepted that Chief Justice Mansfield's decision in the Somerset case is difficult to understand, it is at least clear on one matter. The kind of dominion that Mr. Somerset's master sought to exercise over him by detaining him on a ship to be transported to Jamaica for sale as a slave was not permitted in England. Now, Chief Justice Mansfield's decision must be confined to the two relatively narrow issues that he faced. Did Mr. Stuart have the right to detain Mr. Somerset on the ship? And secondly, did he have the right to have him forcibly transported to Jamaica to be sold as a slave? The Chief Justice's decision that he did not have that right did not abolish slavery in the British Empire. And although Mr. Somerset was discharged from detention on the basis of the writ of habeas corpus, he remained in the service of Mr. Stuart. But notwithstanding the limited scope of the decision, it is clear from the Chief Justice's reasoning that he was addressing the kind of dominion of a master over a slave that only comes with transatlantic chattel slavery. The Chief Justice acknowledged that a contract for the sale of a slave was recognized under English law. But he held that such a contract was not the issue in the case. Rather, he reasoned that the person of the slave himself is immediately the object of the inquiry, and that made a material difference. Mr. Stuart, he said, advances no claim on contracts. He rests his whole demand on the right to the Negro as slave. the Chief Justice paid particular attention to the return on the writ, which included the statement that the laws of Jamaica and Virginia authorized the sale of slaves on the basis that they were chattels. So that for the Chief Justice, the only question was whether the cause on the return was sufficient, whether it provided a sufficient basis in English law for the action taken by Mr. Stewart. So in light of the foregoing, it is beyond doubt that when the Chief Justice held that the detention of Mr. Somerset for the purpose of transporting him to Jamaica for sale as a slave constituted an act of dominion not recognized in England, he was talking about the features of transatlantic chattel slavery. And in my view, Somerset's case is also good law for the distinction between slavish servitude that was permitted on English soil and transatlantic chattel slavery that was not permitted. That the wrongfulness of chattel slavery is determined by the law of the place where enslavement occurred finds support in the Chief Justice's holding that so high an act of dominion must be recognized by the law of the country where it is used. Had the 9th edition examined state practice in West Africa, it would have found that there was no such law in that region. To borrow the well-known mantra from the earlier English case of Cartwright, in which Mr. Cartwright scourged his Russian slave, it may be asserted that just as the English air was too pure for slaves to breathe, so was the West African air in relation to transatlantic chattel slavery. In other words, the West African air was as intolerant of transatlantic chattel slavery as the English air. It is agreed by scholars that Somerset's case was an early conflict of laws case. Thus, the court was principally concerned with a choice between the law that England applied to Virginia or to Jamaica as colonies and the law that it applied in the metropole. And admittedly, it was not a public international law case, but one cannot help but notice the total absence in the case of any reference to the place where the transaction leading to Mr. Somerset's enslavement took place, that is West Africa. Now, ladies and gentlemen, given that England and more than likely other European states did not permit chattel slavery on their soil, the 9th edition should have examined state practice, not only in Africa, but also in other parts of the world, such as Asia, where transatlantic chattel slavery was also unknown, and determine whether it was permitted. European practice alone cannot provide a basis for the conclusion that transatlantic chattel slavery was not permitted by customary international law at the beginning of the 19th century. A determination as to whether transatlantic chattel slavery was wrongful under customary international law at the time it was carried out is therefore flawed if it is confined to an examination of European practice. The 9th edition would also have to consider what constitutes evidence of the absence of a law permitting chattel slavery in West Africa. The report of Somerset's case shows that the lawyers devoted a lot of attention to the question whether trover, that is an action to recover property taken from its owner, would lie for taking a Negro slave. Now, one cannot be certain whether there was in West Africa a law, custom, or practice that would be equivalent to trousseau. But of course, the absence of such a law or custom prohibiting transatlantic chattel slavery in West Africa does not mean that West African law permitted chattel slavery. In the same way that Chief Justice Mansfield established that there was no law in England permitting the kind of dominion through transatlantic chattel slavery that Mr. Stuart sought to exercise over Mr. Somerset, it can equally be established that there was no law in West Africa permitting the kind of dominion exercised by Europeans over West Africans through chattel slavery. And if it is contended that there should be some evidence that in West Africa, those persons involved in the transatlantic slave trade were punished, it should be noted that an international wrong may or may not be a crime. The essence of the wrong is the breach of an international obligation owed to a claimant state. Now, the need to take into account practice other than that of European states in considering the wrongfulness of transatlantic chattel slavery is addressed by Dr. Erpelding in his paper, noting that African countries did take measures to stop or restrict the slave trade. He argues that such African negative attitudes towards transatlantic chattel slavery might cast doubt on the legality of mass deportations resulting in the depopulation of whole regions. He concludes that a broader examination of state practice might show that European regional practice was at variance with the universal law of nations. He believes that this question requires further analysis. Ladies and gentlemen, in West Africa, there was strong antipathy and resistance to transatlantic chattel slavery. Yes, there was complicity by West Africans, but the resistance in West Africa to the practice of chattel slavery contradicted the argument about complicity. The phenomenon of resistance has a special significance. Europeans and others argue that West Africans were complicit in transatlantic chattel slavery, apparently to suggest that that complicity wiped out any international wrong that was committed by that practice. But as a matter of fact, the very opposite of complicity, was intense and unrelenting. The Oba, the king of Benin, 1504 to 1550, actively opposed the capture and enslavement of his people and seized slave ships. One may also refer to the letter of King Alfonso of the Congo in 1526 to his Portuguese counterpart, stating that it is our will that the kingdoms of Congo, in the kingdoms of Congo, there should not be any trade in slaves, nor market for slaves. This resistance to transatlantic chattel slavery became even more pronounced in the reign of King Alvaro of the Congo, 1567, 1587. He sent his officials to Lisbon in 1568 to conduct an inquest into illegal Portuguese trading in the ports. And we also can refer to Queen Nzinga of Angola, 1583 to to 1663. During her reign of 37 years, she became famous for fighting Portuguese enslavement of her people. A statue now stands in her honor in her country. In 1720, the King of Guinea obstructed European traders and killed the middlemen who were captured. And evidence can be provided not only of resistance in West Africa, but also in the Middle Passage, in which there were numerous revolts, as well as in the Americas and the Caribbean. There are more slave revolts in Jamaica than in any other British colony, including the 13 in what is now the United States of America. And as we know, resistance in Haiti was so strong that in 1804, the French colonial government was overthrown and Haiti became the first Black republic. And as Nora Whitman has pointed out in her paper, from the early 16th century on, an African militia patrolled the Gulf of Guinea and attacked European slave vessels. And she states that there was also resistance by various chiefs and kings, and that up to the mid-18th century, not a single year passed without groups of Africans in permanent rebellion attacking some slave vessel. Now, ladies and gentlemen, it is appropriate to cite resistance in countries outside Africa because transatlantic chattel slavery, as I stated, had several stages, including the Middle Passage and forced and free labor in the Americas and the Caribbean. Now, quite apart from the evidence showing resistance from contemporaneous African rulers opposed to transatlantic chattel slavery, resistance from individual West Africans, whether inside or outside Africa, serves to inform understandings of the practice of the states involved. In sum, the resistance of African rulers and their West African people may be seen as a West African resistance to transatlantic chattel slavery, sufficient not only to rebut the argument about African collaboration, but also to show that that kind of slavery was not permitted in the region. And we have already seen that the practice in the Ottoman Empire, described by some as chattel slavery, bears absolutely no comparison with transatlantic chattel slavery. And so it is safe to assert that the incidents of transatlantic chattel slavery were not only unknown outside the countries of Western Europe and their colonies, but also that they would not have been permitted. It is therefore reasonable to conclude that customary international law did not condone transatlantic chattel slavery. And this conclusion is buttressed by the acknowledgement of the signatories of the 1815 Vienna Declaration, and here I quote, that the commerce known by the name of slave trade has been considered by just and enlightened men of all ages as repugnant to the principles of humanity and universal morality. Ladies and gentlemen, there was, in my view, running throughout the entire period of transatlantic chattel slavery, a strong undercurrent of a normative principle calling for respect of the inherent dignity and worth of the human person. And 7 years after the Vienna Declaration, one can refer to the reference made by Justice Story in a case before him in the United States. Justice Story said, the slave trade was founded in violation of some of the first principles which ought to govern nations. It is repugnant to the great principles of Christian duty, the dictates of natural religion, and the obligations of good faith and morality, and the eternal maxims of social justice. Ladies and gentlemen, the breach of that norm by transatlantic chattel slavery does not mean that it did not have a binding character. It may even be that the West African practice could be considered alongside the European regional practice, but the 9th edition never bothered to examine the practice in Europe, in Africa, or elsewhere. It simply proceeds to a more categoric statement than the 8th edition without providing any basis for its more confident posture. The 9th edition, ladies and gentlemen, would have to confront the dichotomous approach of European slaveholding countries to transatlantic chattel slavery. Its features or incidents were not permitted in the metropolitan countries, but were allowed in the colonies. But if the practice of chattel slavery was, as a matter of international law, wrongful conduct, a slave-holding state could not invoke its domestic law as justification for its breach of international law. Article 3 of the ILC's Articles on State Responsibility states that the characterization of state conduct as wrongful is governed by international law, and that characterization is not affected by the characterization of the same conduct as lawful by domestic law. Now, the question arises whether this rule would have been applicable in the period of transatlantic chattel slavery. If that rule is applicable, then the domestic laws of England and other European states that permitted chattel slavery in their colonies, in the Americas and the Caribbean, could not be invoked as justification for breaching what I have argued was a rule of the law of nations condemning chattel slavery. I hold the view that the rule in Article 3 would have been applicable in the period of transatlantic chattel slavery. And I give this as an example. If in 1600, a state had laws that allowed for or condoned the mistreatment of ambassadors in its country, and an ambassador was mistreated, that state could not invoke its domestic law as justification for what would be a breach of one of the oldest rules of customary international law, that is the inviolability of the person of an ambassador. Transatlantic chattel slavery commenced about 1450, when the first West African was transported to the Americas, and ended in 1888, when the enslaved in Brazil were emancipated, a period of almost 4.5 centuries. The global sweep that is involved in the 9th edition's brief analysis is inappropriate for a consideration of the wrongfulness of transatlantic chattel slavery under customary international law. And it seems to me that the contention that that law did not condemn slavery at the beginning of the 19th century must surely require an examination of customary law at various periods. For example, 1450 to 1550, 1550 to 1650, 1650 to 1750, and 1750 to 1888. And so although this symposium does include a presentation that was global in scope. It did have other presentations devoted to an analysis of international law at various periods in transatlantic chattel slavery. In conclusion, ladies and gentlemen, there is evidence that at the beginning of the 19th century, customary international law did condemn the institution of transatlantic chattel slavery. In fact, as the symposium has shown, customary international law condemned the institution of transatlantic chattel slavery from its very beginning. That concludes my presentation on that subject, ladies and gentlemen. And since the organizers have been unkind to me, I have been presented with a double role, and I must now move, with your permission and patience, into my closing remarks. And I want to begin by saying how grateful I am for all the presentations. Every presentation was interesting and helpful in understanding transatlantic chattel slavery and explaining why it was conduct that was not permitted by international law at the time it was carried out. The presentations and the discussion were of a very high caliber. My thanks to Professor Hilary Beckles for his two presentations. His global assessment of the reparations that are due for transatlantic chattel slavery will be critically important in the work of the next symposium that will be devoted to an assessment of the reparations due under international law. Now, the date of that symposium will be announced shortly. So you now know that I have formally told you that there will be another symposium specifically devoted to the assessment of reparations that are due under international law for transatlantic chattel slavery. And Sir Hilary's presentation on the quantification of reparations shows precisely how difficult it will be to determine reparations that are due under international law. And by the way, his presentation should have been worded, in my view, assessment rather than quantification of reparations. The assessment of reparations will include quantifications, but it will also include, as you just heard from Professor Sands, satisfaction addressed in Article 37 of the ILC's articles on responsibility of states for internationally wrongful acts. And satisfaction, as you heard, includes an acknowledgement of the breach, an expression of regret, a formal apology, or any other appropriate modality. The former slaveholding countries are to be required to make an apology. Sir Hilary pointed to one methodology for quantifying reparations that showed that trillions of pounds would be due in excess of the gross domestic product of the United Kingdom. The extent of the sums due is no doubt mind-boggling. Determining the methodology for reparations will be exceedingly difficult. And Sir Hilary's comments confirm the wisdom of the decision to devote another symposium to the assessment of reparations. The question has been raised, whether reparations will result in the payment of sums of money to individuals as descendants of the enslaved. And I've been asked here in Jamaica when Jamaicans can expect to see money in their bank accounts. Perhaps the question was a bit sarcastic. Now, Sir Hillary referred to his colleague, historian, Professor William Darity of Duke University in the USA, who has advocated the payment of specific sums of money to the descendants of the enslaved in the USA. I have read Professor Darity's article entitled 40 Acres and a Mule in the 21st Century. I appreciate the article very much. However, I am personally not in favor of reparations taking that form. At any rate, not for the descendants of the enslaved in the Caribbean. Those enslaved and their descendants have suffered immensely from transatlantic chattel slavery in terms of their education, their health, their personal development, and more generally, their economic well-being. The sums resulting from reparations should, in my view, be applied to promote the development of the descendants of the enslaved and the countries in which they live. They should be used to build schools, universities, hospitals, and used in any other way that would promote personal and national development. I do not, of course, rule out the payment of monies in countries where that would be more feasible, like the United States, though I would still believe that the preferred course would be to apply the reparation sums to the development of particular communities that have been adversely affected by the consequences of transatlantic chattel slavery. In Nora Whitman's presentation, she stressed the difference between servile labor and transatlantic chattel slavery. And she pointed to the extent of the resistance to that kind of slavery, which she concluded was unlawful. I found quite interesting Nora's view that transatlantic chattel slavery violated a general principle of law calling for respect of the dignity and humanity of West Africans. She was bold enough to say that this principle had the status of jus cogens, a peremptory norm of general international law from which no derogation is permitted. I believe there is merit in Nora's argument. And if you recall, I commented on that issue in my presentation. With the rise of positivism in modern international law, there's a tendency to criticize argumentation that has its basis in natural law. My own position, though, is that the fundamental requirement of international human rights law today, that is respect for the inherent dignity and worth of the human person, that is reflected in the 1948 Universal Declaration on Human Rights and so many other instruments, can be traced back to an era even before the commencement of transatlantic chattel slavery. It finds expression in the common law, in the law of European countries such as France, where in general the position that once a slave reached France, he became free. because France was the mother of freedom. That principle, reflected in the law of Britain, France, and other slaveholding countries, was breached by transatlantic chattel slavery. The breach identifies the existence of the principle and does not detract from its validity. And that is why I believe there is merit in Noor's argument. In the period-by-period analysis, we heard from Dr. Mamadou Hebe, who showed very clearly, in my view, that the just war doctrine did not provide a basis for transatlantic chattel slavery in the period between 1450 to 1550. And Parvati Menon, who addressed the period between 1550 and 1815, stressed that European law was not universal, and she also adverted to the resistance to transatlantic chattel slavery. Dr. Michel Erpelding provided an insightful and stimulating analysis of transatlantic chattel slavery in the period from the Vienna Congress of 1815 to 1888. And we all have to be grateful to Dr. or Professor Patricia Sellers for her presentation on sexualized practices and institutions in the slave trade and slavery. And she is so right that reparations must take account of the harm to women and their families resulting from these practices. The significance of her presentation is that it showed that reparations must in no way be confined to the forced and free labor of West Africans on the plantations. Ladies and gentlemen, the largest Black population in the world outside Africa is to be found in Brazil. And the symposium would not have been complete without hearing from Mr. Adami. He highlighted the problems faced by Blacks in securing reparations. And he preferred to speak of Black slavery. And I understand. It shows how racialized chattel slavery was. I like very much his rousing call at the end. Let's make the ground tremble. So may I say to all of you, let's make the ground tremble with the cry for reparations. Professor Claudio Grossman, my former colleague on the Inter-American Commission on Human Rights, also gave a stimulating presentation that will be helpful in crafting remedies for transatlantic chattel slavery. I am especially grateful for the presentations on contemporary dimensions of transatlantic chattel slavery, the present day consequences of which stare us daily in the face. Professor Achiume addressed reparations for racial discrimination rooted in colonialism and slavery. And she also showed that the conclusion that transatlantic chattel slavery violated a rule of international law did not breach the intertemporal rule, which requires that the breach be established on the basis of law applicable at the time of wrongful conduct. The symposium is indeed very fortunate to have the UN's special rapporteur on the subject of racism address us. Professor Eric Miller's presentation on the relatively recent Tulsa massacre was thoughtful and informative. We will be following closely the court proceedings for reparations for an act that undoubtedly had its roots in the practice of transatlantic chattel slavery. Professor Miller referred to his Jamaican family. I am proud to tell you that I'm part of that family, and to tell him that his grand aunt, my mother, would have been very proud of the activist role that he's now playing in reparations for the Tulsa massacre. And we have to be grateful for Professor Philip Sands' wide-ranging, illuminating, and absolutely brilliant presentation on contemporary institutionalized racism as a breach of international human rights law. If you are not convinced before about the link between contemporary institutionalized racism and transatlantic chattel slavery, you would have been after his presentation. I express my gratitude to him. So may I tell you, ladies and gentlemen, that as a whole, in my view, the presentations show that at the time of transatlantic chattel slavery, there was a rule of customary international law that practice was wrongful and entailed the international responsibility of the states that carried it out. And accordingly, reparations are due. Reparations will provide healing. And to pick up on a point made by Professor Sands, may I say that absent something like a Truth and Justice and Reconciliation Commission in the United States, leading to a national reckoning, followed by reparations for the descendants of those who were enslaved. Racial harmony in the United States will remain a far off and distant dream, never to be attained. Further, ladies and gentlemen, may I suggest that we, whether descendants of the enslaved or not, have been handed a sacred trust that we must execute, and will only execute by staying the course until the struggle for reparations for the grotesque crime of transatlantic chattel slavery has succeeded. Those of us living in countries where our ancestors were enslaved have a moral obligation to fight for reparations. It is a debt that we owe our ancestors. Following the abolition of slavery in the Caribbean, the 13 colonies of Britain in the Americas, and in Brazil and other countries, those who were freed endured over 100 years of apartheid. And so in many respects, although our ancestors, whether enslaved or freed, resisted transatlantic chattel slavery and apartheid, we are the first generation to be in a position to make a strong claim for reparations and to press for it with all our might. We must not be deterred by the naysayers. We must not be cajoled by the frivolous argument that transatlantic chattel slavery should be forgotten because it happened centuries ago. the powerful presentations on contemporary racism as a legacy of chattel slavery by Professors Achiume and Sands contradict flatly that way of thinking. In my view, a settlement is needed on the reparations issue. That settlement must, however, proceed on the basis of an acknowledgement that transatlantic chattel slavery was wrongful conduct. The power imbalance between Caribbean countries and former slaveholding countries should not be allowed to stand in the way of the quest for reparations. The power imbalance between slave owners and the enslaved did not prevent them from, as the great Jamaican singer Beres Hammond said, putting up resistance. May I say thanks to all those who have worked so hard to make the symposium the success it has been. May I extend my gratitude to Victoria Mutual Building Society and the Gleaner RJR for their sponsorship. And a special thanks to the American Society of International Law for agreeing to my proposal as its honorary president to convene this symposium. And in that regard, thanks to President Amir Farr, to Natalie Reid, and Professor Chantal Thomas. And thanks also to the University of the West Indies for collaborating with the American Society of International Law. And in that regard, a special thanks to the Vice Chancellor, Sir Hilary Beckles, and Professor Vereen Shepherd for their role in support of the symposium. And thanks to all of you who have joined in. And finally, may I ask you to be on the lookout for the date of the follow-up symposium that will address reparations under international law for transatlantic chattel slavery. Thank you very much, ladies and gentlemen. Goodbye.